allotted land, in spite of knowledge order to check and pass order, my lord, we are demolished. Residential houses and my shop houses are demolished. And my lord, now we are under the sky, my lord. So my lord, contempt file, my lord, on last 3 days back, my lord. Can it be listed, my lord, on Wednesday? My lord? Okay.
No, with the consent of the petitioner, my victim is item number 44, man.
44.
44, man. We taken after 2 weeks, man. My friend is here in the for the petitioner, man.
44.
44.
Who is for the petitioner?
I
am.
Okay, K.R. Patgiri, Learned Counsel for the petitioners is present. Mr. S. Bora. You want it next week?
Man, let it be after 2 weeks, man, because the respondent will be engaging it to another state of advocate, man.
Okay. Now, Mr. S. Bora, Learned Counsel appearing for the sole respondent, has sought for listing of the case after 2 weeks. As the prayer is made with the consent of the Learned Counsel for the petition, the prayer is allowed, list the case after 2 weeks on a date to be fixed by the office.
May it please your worship. Well, so far as item numbers 39 and 40 are concerned, although it is only for reflection of the correct address, respond number 5 and no more, but the issue relates to removal of a secretary by a board. And the Bikrampur matter, with lordship is author, that is under appeal on the 5th. So whatever is, it would follow up here also. So may I pray sometime towards the end of December, this matter may be fixed, vote of this. That is read appeal 120 of 2025.
Item number?
39 and 40. I mean,
What is the issue here?
issue is secretary was removed by the board. It was challenged. They stay operating with the liberty. You can proceed afresh. They proceeded afresh, removing me again. This is 40 now. First one was 39.
Removal of secretary.
Removal of secretary by the board. So by and large, the issue would be touched in that appeal. So therefore, that appeal is fixed on the 5th. If I may pray, it may come towards the end of December.
Okay, on the prayer of Mr. S. Bonik, Learned Counsel for the petitioners, this is the case is on 17/12.
May it please, Your Lordship. With the consent of the petitioner, I beg to mention
Counsel
item number 48, Lordship.
48.
Lordship. In this case, Lordship, we are going to file our Ukalat Nama, Lordship, for respond number 6, Lordship.
Miss E.
Lordship, R. Deka.
R. Deka. Learned Counsel, you have entered appearance for response number 6.
Lordship. And Senior Counsel B.D. Das, Lordship, on behalf.
R. Deka, Learned Counsel has submitted that she has entered appearance for the response number 6 by filing a color number recently. Yes.
I am for the petitioner, Lordship.
Mr.
M. Hussain.
M. Hussain, Learned Counsel for the petitioner is present. As sought for by Learned Counsel for the parties, release the case after 1 week.
After 2 weeks, Lordship. In the meantime, we will file our affidavit, Lordship.
After 2 weeks to enable the response number 6 to file its counter affidavit.
May it please, Your Lordship. May it please, Your Lordship, I beg to mention item number 14 and 15. I have taken the consent of the other side.
14 and 15.
This matter may come after 2 weeks, my lord.
14 and 15. What is the matter?
Matter is regarding the my patta was cancelled, my lord.
S. Kanongo. You are appearing for whom?
I am for the petitioner.
14, 15.
14, 15.
Okay, S. Roy, Learned Counsel for the petitioners has sought listing the case after 2 weeks.
2 weeks.
Okay. The praise involved as the praise made with the Learned Counsel for the respondents, with the consent of the Learned Counsel for the respondents. Please the cases of the 2 weeks on the date fixed by the office.
May it please Your Lordship.
Yes.
Yes.
May it please Your Lordship. I beg to mention listing of I, Lordship, for typographical error, Lordship.
Okay, give it for a court master.
Lordship, 22 mile pairs of dealers, Lordship, filed the petition, Lordship.
22.
22, Lordship. On 27th 2025, my lord.
Item number 22. Item number 22.
No, Lordship. Fresh case, Lordship. On motion, Lordship. My lord, on 27/11, it was filed, Lordship. My lord, case is, Lordship, as regards my lord, distribution of the, my lord, essential commodities, Lordship, there, my lord, allotments were cancelled, my lord, given to some others, Lordship. So urgency is there, may I pray for tomorrow or day after tomorrow, Lordship?
Wednesday.
Obligation.
May 12.
Lordship, I am for a listing of pending matters, Lordship. We have challenged the Panchayat election, Lordship. It is a very interesting matter, Lordship. 2 of the petitioners were candidates. and two of the petitioner were not candidate, Lordship. Your Lordship has already passed that so far as candidate is concerned, it is the jurisdictional tribunal, Lordship. But here in this case, Lordship, Huzai district, no tribunal is formed, Lordship. So
Now it has been notified, it has been formed.
Lordship, it may be, Lordship,
When is it?
Lordship, it may take enough.
When is it? When is it?
Lordship, on 9th, Lordship.
9th.
Yes, Lord.
9th is the new matter.
No, Lordship, pending matter, Lordship.
Okay, 8.
Lordship, 9th, Lordship, 8th, I will be not available. Lordship.
Then 10th.
10th, Lordship. How like that?
Wait, Lordship. I beg to mention item number 49, Lordship. In this case, I have to file one application for amendment. So, matter may be adjourned for today and make fix after 2 weeks.
Mr. R. Sharma, learned counsel for the petition, has submitted that he needs to file an appropriate pleading. In this case, for which he needs 1 week time. Post of he has just sought for listing of the case after 1 week. Post of the prayer is allowed as the prayer is made with the consent of the. You have informed the other side.
Lordship, no, today is a returnable date, first returnable date.
There are many council,
Standing
Silchar
council,
Municipal Board, Standing Council.
I shall inform them, Lordship.
I am recording.
Yes.
Consent has been taken.
May I please, Lordship? Lordship, I beg to mention for listing of an IA, Lordship. The respondents are going to demolish our property, Lordship. So kindly this matter.
Friday.
No, Wednesday, Lordship. Otherwise, Lordship, they will demolish our property, Lordship. Wednesday.
May I please, your Lordship. Lordship, I'm praying for listing of this repetition in the orders column, Lordship.
Give it to the court master.
My lord, I have some urgent matter, land acquisition matter, my lord. Since
Land acquisition, what is the urgency?
since long back matter has not been listed.
Okay, give it to the court master.
Wait, please, Your Lordship, I beg to mention item number 43. I have taken consent from the respondent side. The matter may kindly be listed after 2 weeks, Lordship.
On the prayer of Mr.
US Bora.
E.S. Bora, learned counsel appearing for the petitioner. The matter stands adjourned for 2 weeks as the prayer is made with the consent of the learning counsel for the respondents. This is the case. After 2 weeks, only need to reach by the office.
Lordship.
May I please,
Obliged.
Lordship? Item number 37. I have taken the consent from the opposite side. So Lordship may kindly list the matter after 2 weeks or after vacation.
Miss,
M. Sharma.
you have informed the other side.
Pardon?
Inform the other side.
Yes.
Miss so and so learned.
Lordship, I am for the opposite petitioners. Item number 37.
37.
Lordship, we have no objection and this matter may be fixed after vacation, Lordship.
Miss so and so learned counsel for the petition and Mr.
S. Fazil.
S.
Fazil.
Fazil. You are on behalf of G. Jalan.
Ji Jalan.
Learned counsel on behalf of Mr. G. Jalan, learned counsel for the respondent 1 to 4 are present. Mr. Miss so and so, learned counsel for the petitioner. Come with the consent of Mr. So and so has prayed for listing of the case after 2 weeks. Prayer is allowed, list the case after 2 weeks.
May it please, Your Lordship. Lordship, with the consent of the other side, I beg to mention item number 11, Lordship.
11.
Yes, Lordship.
Yes. You are for the petitioner?
No, Lordship. I'm for the respondent 123, Lordship. IOC, Lordship.
You have informed the other side?
Yes, Lordship.
Okay. With the consent of the learned counsel for the petitioner,
No,
Mr.
Lordship, may kindly fix the matter after the vacation, Lordship.
Your name, please?
R. Gohai.
R. Gohai, learned counsel for the respondent number 1 to 3. Has paid for listing of the case after 3 weeks. The appraisal allowed list the case after 3 weeks, only need to fix by the office.
May it please, your Lordship. Lordship, with the consent of the other party, I beg to mention item number 55 for an adjournment, Lordship. Lordship?
55.
If convenient, Lordship, the matter may be listed on 5th of this month, the Lordship. In the intervening period, we'll be filing our
No.
the IA.
Next week.
My lord, we have
On the prayer of Mr. Miss
M. Das.
M. Das, you are for whom?
Lordship, for the petitioner.
This is stay vacating application, my lord, filed by us, my lord.
You will fix it?
On 5th, my lord, kindly, my lord. We have some urgency in the matter. Today-
On an 88.
Matter is fixed, my lord.
On the prayer of Miss, you are for?
I am
You are for the petitioner, she is for the
This
petitioner.
is for the petitioner, I am for the applicant. This is the IA, my lord.
Okay,
IA for stay vacating, my lord.
okay. We put it in the appropriate column.
Yes, my lord. On fifth.
On, no, 8. On the prayer of Miss M. Das, Learning Council for the petition. A prayer for adjournment is made by Ms. So-and-so, Learning Council for the petition. Mr. R.M. Deka, Learning Council has submitted that he has filed an application for, interlocutory application for vacating the interim
Yes, my
order.
lord.
I number will লিখি দিব। List the repetition along with I in the appropriate column on it. 8.
Lordship,
May I
there is
please
an
your
interim
lordship?
lordship.
Interim order past shall continue till the next set of question.
Great.
May I please, your lordship, my lord, item number 27, affidavit in opposition already filed by me, I am respondent number 7. So this may be tagged with my lord.
It will be definitely,
27 item.
huh?
Affidavit in opposition already filed by me, as a respondent number
Okay,
7.
okay, you want to bring it on record?
Yes, I want to bring it.
Give it.
May I please, your lordship? May I be permitted to move in motion matter on Wednesday?
What is
My
the
lord,
subject?
Urgency, my lord, is that the circle officer has issued in, my lord, notice addressing the IO of that particular area, by which, my lord, I have been restrained from entering to my pattal. And
Okay.
my lord, may I point out one thing, my lord? This
Okay, wait a
No,
second.
no, one thing, my lord, may I point out? Last Friday, this matter came up, but I could not appear because I was busy in another court. That is why I have mentioned this matter again. Oblige.
May I please, your lordship, with the consent from the other side, I beg to mention item number 16, lordship. Lordship will be filing our affidavit, 2 weeks may be granted, lordship.
You have informed, who is the
Lordship,
for the petitioner? Mr.
B Sharma.
B. Sharma, Learned Counsel for the petition is present. Mr. K. Jain, Learned Counsel on behalf of Mr. S. C. Kyle,
Lordship.
Learned Standing Counsel, CGST, has prayed for and is granted 2 weeks time to file counter affidavit on behalf of the respondent CGST authorities. Release the case accordingly after 2 weeks, so nearly 2 weeks made of this.
That's an interim, lordship.
Interim order, but shall continue.
Much obliged, lordship.
Right, Mr. Lordship, I prayed for listing a pending matter, my lord, on Wednesday, my lord.
Why Wednesday? What is the subject matter?
Subject matter, my lord, the Patta land shown as a government land, my lord, without assigning any region, my lord.
Affidavit filed?
No, not yet filed.
Not yet filed?
Not yet.
Then, okay, Wednesday.
Obliged.
May I please, your lordship, I beg to mention item number 31 for adjournment, your lordship.
31.
Yes, as the senior counsel is out of station for some personal matter, your lordship.
31. Yes, your name?
J. Rahman on.
On the
petition,
prayer of
your
Ms.
lordship.
On the Mr. J. Raman, Learned Counsel appearing for the petition and release the case after 2 weeks. First of all,
Your
informed.
lordship.
It is stated.
Your lordship.
Consent has been taken from the Learned Counsel for the respondents to make the prayer. Yes,
Your lordship, if it is convenient,
after 2 weeks. Next.
My lord, item number 8, my lord. An additional affidavit has been filed by the revenue department. We need to file a reply,
Item number 8.
my lord.
Yes,
One additional affidavit was filed by the revenue department. We need to file a reply to that.
additional affidavit in reply.
My lord, the problem is that they have brought on record one RIP deed by virtue of which my name has been stuck down. So,
Mr.
H.K. Sharma, my lord.
H.K. Sharma, Learned Counsel for the petition. How much time you need?
2 weeks, my lord.
So straightforward. And is granted 2 weeks time to file and reply to the additional affidavit stated to have been filed by the state respondents. Very loudly is the case after 2 weeks.
Much.
may I please, your lordship, I beg to mention for withdrawal, my lord. The matter has become infractious, my lord, on 3rd, my lord. Day after tomorrow.
Daily list for motion, item 1.
Holy has it. They only has.
Make use, your lordship.
1 minute. Yes.
The instructions, lordship, we have not received, lordship, awaiting instruction. The OC has not yet been sent the status report, lordship.
My lord, this matter pertains to that previous freezing of the bank account on account of suspicious transaction. And lodging of 2-3 police complaints pertaining to the same UTR number, my lord.
Yes, Mr. Roy.
Lordship not received some time, Lordship.
Ajara,
Lordship. Wednesday, Lordship. We have
Friday.
Lordship.
Mr. D. Rathi, learned counsel for the petitioner is present. Mr. S. S. Roy, learned junior government advocate Assam, has submitted that he is yet to receive the instruction in deference to the order dated 17/11/2025. First of, he has sought listing of the case on Friday in order to obtain the necessary instruction. First of, list the case accordingly on Friday.
512.
Lordship.
Deeply obliged.
Item 2.
Here, please, Your Lordship. Limited prayer, Your Lordship. Actually, I filed one letter before the circle officer. I had misplaced my.
Yes, what is there any provision?
I am 86 years old.
If there
I'm
is any
harassed.
provision, it could be only duplicate.
Lordship.
Yeah,
Periodic
yes.
pata.
Apply online application.
Where is the provision? Let us see.
ARTP.
Tell me, we'll dispose of.
Lordship.
If it is online, show me after some time.
Ground is Your Lord.
Huh?
After some time.
Provide.
Take
Ground is
instruction, we'll dispose of, no point keeping it.
Yes, Your Lordship. Ground is Your Lordship. There was a case before this honorable court. I was the petitioner.
Whatever, if you are the patta holder and if there is provision for duplicate periodic patta, definitely you have to apply according to the proper procedure. Let Ms. Hazarika get the instruction.
Item number 3. Item 3.
Heard Mr. D.P. Bora, learned counsel for the petitioner. One, Mr. Roy.
Lordship. I'm for one, only one, Lordship.
S.S. Roy, learned junior government advocate Assam for the respondent number 1. GMC, H. Burua, on behalf of learned counsel, on behalf of Mr. P. Nair, and standing counsel GMC for the respondent number, no, GMC, GMD. GMC, Roman and GMD for the respondent number 2.
2 and 3. 2 and 3, my lord.
Chief Inspector, lift. I think S.S. Roy.
So, Lordship.
1 and 5.
1 and 5.
Mr. B. Chaudhary. And standing counsel PDCL for the respondent number
4.
Yes, what is the issue?
My lord, issue is that, my lord, the building of the respondent number 5 and the petitioner is adjacent, my lord. So there are several irregular.
Unauthorized construction
Unauthorized construction, my lord.
of respondent number 6.
Yes, my lord.
You file complaint.
Yes, my lord.
Inaction.
Inaction.
Okay. Petitioner has approached this court by the Senate petition stating inter alia that despite lodgement of complaint before the respondent authorities, more particularly, the respondent GMC and GMD,
GMC, GMDA and APDCL also.
APDCL authorities regarding unauthorized construction on the part of respondent number 6, the respondent authorities have shown apparently there is apparent inaction on the part of the respondent authorities to act on the complaints post of issue notice returnable on so and so as so and so appeared, accepted, formal notice dispensed with, extra copies within 2 working days from today. The petitioner shall take steps for service of notice upon the respondent number 6 by speed post within 2 working days from today. This is the case. The respondent authority shall ensure that its affidavits are filed within honor before the return executive.
5-1, 5th January.
Obliged, my lord.
Item 4.
Permanent resident voter. Not having agreed for being the candidate to win the. After election, what? Election petition or?
My lord, for this purpose, my lord, there is, DC doesn't have any power. So perhaps election petition is the only remedy, my lord.
What kind of qualification? Respond number 8 does not have
HSLC.
HSLC.
Yes, sir.
What privacy evidence you have?
Lordship, page number 26. Last page, Lordship. Last line, division remarks failed. Along with the representation, we have annexed and submitted it before the respondent number
Is
4.
the issue settled after election? Is the issue
Not-
settled?
This issue is still pending, my lord, but my submission will be, my lord, that for this purpose, Deputy District Commissioner doesn't have any power.
But 111 Panchayat Act.
Yes.
For executive qualification.
No, number of petitions are being filed. I have seen number of
Yes.
petitions
Yes,
with same kind of allegation.
my lord.
11 disqualification. No person will be elected. What is the provision here?
My lord, 111, my lord.
111? What? Which one?
2B, Lordship.
2?
B. Lordship, I am
B.
referring one order that may be perused, Lordship. This issue has been considered by this honorable court earlier.
Notice is
2.
No, it is-
B.
My provision of who will be this one. No. Rule is not there, Your Lordship. What will happen so far as the qualification is concerned, Your Lordship?
The decision shall be absent for. No person shall be elected, co-opted and remain as president. Who is the power for the district commissioner?
There is no power, Your Lordship. I have referred one order that may be perused. Pura copy is in our signature.
Who is the rule?
My lord, Rule 62(2),
62(2).
Assam Panchayat Constitution Rules, 1995.
Notice issue. Tension of issue.
62-2.
Yes, my lord.
I have read.
Subject to the provisions of the Act, at the time of filing of nomination, candidates shall furnish affidavit regarding their required educational qualification along with true copy of such certificates, and also should produce the original certificates before the concerned authorized officer, failing which concerned candidates shall be disqualified.
That is.
That is on, yes, that is for the educational qualification.
62-2.
Two.
This is Silbert. The
Silbert
judgment
is a different.
order you have placed,
Yes.
Mr. Counsel.
No,
This
no,
is Silbert.
no, everything has been referred, your lordship, in the, with regard to your lordship, may kindly see. Or miss. The condition procedure for disqualification under section 2 of section 7, so paragraph 6, your lordship.
Read paragraph 5 first.
Section 112 of the Act outlines the condition and procedure for disqualification franchise primarily on the ground of having more
Two
than.
children, more children.
Every-
6. 6 also 2 children.
Yes, lordship. Now, in terms of receipt of information from the aforesaid mandate of law, the
62,
procedure
yeah.
prescribed is a very clear that procedure has
No, sir.
removal of member.
I don't think so. This is applicable.
No, it is.
This is Silbert. Specifically, provision has been laid down in the rules.
Yes. Lordship, kindly see paragraph 4, your lordship.
Paragraph 4.
This has been discussed, your lordship, since there is no rule. Paragraph 4, your lordship. They raised a grievance against respondent number 564 seeking their display on the ground that respondent number so did not possess the required qualification, education qualification which entails them to be disqualified.
Where it is addressed?
Now, lordship may kindly see paragraph number. At this stage, Mr. Mohan Tulane, senior counsel for the
Which
respondent.
paragraph?
Paragraph 15, your lordship. At this stage, Mr. Mohan Tulane, senior counsel for respondent number so contains that the deputy commissioner is not vested with the jurisdiction to entertain the application filed by the prisoner for disqualification, more particularly found to of jurisdictional fact required for such data. According to Mr. Mohanto, learned senior counsel, though the deputy commissioner can disqualify candidate when the said candidate does not possess required education qualification. However, in the case in hand, the allegation of the petitioner as regard the genuineness of the certificate cannot be determined by the deputy commissioner. That was the genuineness of the certificate, your lordship. Powers under section 112.
What is 62(1)(b)?
Yes, lordship. 62(1)(b).
62(1)(b).
Yes.
62(1)(b), my lord. More than 2 children, my lord.
More than 2 children.
Yes.
111(2)(a).
111.
What is that? 62(1)(b).
2A is the, my lord.
1B
more than 2 children.
is 2 children. 111.
11A also more than 2 children.
This is only decided that aspect.
Yes, lordship.
The other aspect is not
Other
decided.
aspect so far as it.
Now come to 129.
Yes, 129B.
There is a bar, lordship.
She got through with the people electing her. Now, what is the notification of under 127?
My lord, at present, I don't have right with me, but I can present.
More than region, isn't it? That was a jurisdictional factor over region.
Sri Bhumi is already there in that list.
Huh?
Sri Bhumi is already there in that list.
Which one?
Under 127 notification.
Ah.
Sri Bhumi is already there, my lord.
Shivumi is there.
Yes.
Now, what are the issue the election commission?
My lord, as per my lord, 120.
Puroni Panchayat election.
Five,
I think in the book it is not there.
book not there, my lord.
In the old book it was there. In the old book, motivation to lay
Notice WhatsApp আসলে প্রকাটাইছে আপনাদের ফকিরা
There is a notification in consultation with the High Court.
Yes, madam.
From us, the notification. Get the notification Wednesday.
Well,
because Article 243O bars it.
Yes, ma'am.
This is regarding child bar.
Lordship, in other similar cases, a notice has been issued, your lordship. Opening
Maybe
this issue of
with time, wise sense may prevail. Show us why notice if it is barred.
Yes.
Yes, Mr. Majumdar, Additional Advocate General. This issue is to be traced. Person contested the election, Panchayat election. Now that a candidate should have HSLC or HSSLC qualification. Nomination filed, affidavit filed, nomination accepted, election held, got elected. Now a complaint is lodged that the person elected does not have the qualification, so she should not or he should not remain as a president or member of Gram Panchayat, Anchalik Panchayat. Now, Article 243O
Yes, ma'am.
and Article Section 129, subsection 2.
Yes.
It normally says about
Election petition.
election petition. On the other hand, there is provision in the Panchayat Act that in case of two or more more than two children,
Madam.
Deputy Commissioner has the jurisdiction to decide and inquire into the complaint. Right? So far as this provision is concerned, the Act is silent. So,
No, but ultimately, if the prayer is to set aside election, then it has to go before the tribunal. Because
so Mr. Counsel,
Lordship,
There is a
petitioner is a voter, your lordship. He was not a contesting candidate.
no issue. No
anybody
issue.
can challenge.
Voter can challenge.
My lord, even in the assembly election, a voter.
Law
can challenge.
law is
Law is very
clear.
clear.
A voter can challenge. You being a resident of say Gwalpar, you cannot go and
Ultimately,
challenge an election in Silchar.
ultimately, what is the prayer? Prayer is that no improper reception of nomination paper. So that can be done. That can be decided only by the election tribunal. Very clear.
And there is a notification, Mr. Dr.
Yes, notification.
Please place it.
Yes, I'll.
About Dostaman.
It's a clear case of improper reception of nomination paper.
Get the notification. Because
Lordship can dispose of today itself.
let us have the notification also.
All right, 2 minor, I'll produce my.
Because petitions are coming thick and fast.
Cannot be entertained, madam. They have to go before the tribunal. Tribunal is considered
Even
deputy
if
commissioner.
Indemnity is an issue. Why should we enter?
Deputy commissioner, no. I think it's the learned district judge. District judge has been given the.
Yeah. Earlier round, I have disposed of a number of petitions.
After
15, 20.
After district judge, writ petition is filed challenging the order passed.
It is already, if it is,
That's it.
the issue is settled,
Yes,
then no point.
So 120, 111,
127 balance, 127. I'm not afraid, so.
Is there any provision in the rules regarding election petition?
Section 120,
9(2).
29. Yes.
And jurisdiction is 127.
The same provision is there in the constitution of Article 329B.
243O.
No,
For Panchayat.
For Panchayat. For assembly and parliament.
329.
329B.
I see. Okay.
Thank you. And in section 129, there is a reference of 243 also, article 243.
Somewhere I had seen the notification.
No, notification is there, man. All such petitions are filed before the district judge.
But can you apprise us on Wednesday along with Mr. Dotto? Wednesday?
That will be Friday, man. Friday.
Wednesday.
Or Thursday. Wednesday.
You are not available. Okay, Mr. Dotto. Are Mojumdar?
Are Chodhiri.
Are Chaudhary, Land Council for the petition, heard. And Mr. S. Dr. Learned Standing Council, Panchayat and Rural Development Department. For the response number 1, 3, 5, 6. S. Roy. Senior Government with 4. Mr. A.B. Kayasa, Land Council on behalf of Mr. R. Dubey, Land Standing Council. Assam State Election Commission for the response number 2. Toto is also for response number 7. Okay. The preliminary issue involved in this situation is whether for seeking disqualification of an elected candidate of a Gaon Panchayat.
Yes.
On the ground of not having the requisite qualification, a election petition or a writ petition is maintainable.
Yeah, most people 11% in again.
There's a notification of 2000.
What's it?
And so we can use it. 21. 21.
Commissioner power dia is called
You need to deal with more stage.
piece of wood, put us into 8 to 9. Porque ese día se tiene que poner después de que puede. This is power ya se por ahí. Into this to 9. Ahí no hay que ir por ahí. Means actual power.
To entertain writ petition or, sorry, it would be aggrieved and aggrieved.
District commissioners
Defeated candidate should maintain a writ petition or an election petition.
notification I have submitted.
Or an election petition. Okay. Release the case on Wednesday.
So we have found the notification.
Ah. After election, I think no other option. There is specific power given in the rules so far as more than 2 children is concerned. So unless that is challenged,
Election stage.
that was decided by this court that anybody can lodge, but here 129 says any contesting candidate.
129.
See? Or notification.
Notifications.
Jurisdiction. Clause.
Yes.
Shall have jurisdiction and entered in dispose of election petition filed before it by any contesting candidate in respect of validity or propriety.
Yes.
So I think validity will come if that person does not have the disqualification, but here it is made limited.
129B is also clear. 129B says, no election to any panchayat election shall be called in question except by an election petition presented within 60 days from the date of a declaration of so-and-so. Except by election petition.
129.
Yes. 129B says, and there is a period of limitation of.
Is there any provision in the rules?
162.
Regarding election petition?
Yes, there has to be.
Mr. Dr. Suhas, otherwise he will be again 60 days limitation period.
That will
60 days.
There is bar. Is there any
These things, my lord, from maybe from the date of knowledge, he can delay can be condemned.
No. from the date it is declared.
Cannot be so elastic. Wednesday.
Hello. Supplementary list, item 50.
Made page, your lordship.
Yes.
Sir, I am challenging the so called notice, my lord, page 41, my lord. Last page, my lord, annexure E. By this so called notice, my lord, the GST of the petition has been suspended, my lord. The lordship will find it, my lord.
41 on the
41.
basis of information which is communicated that your registration is liable to be in 21 MA 51 E. Alright.
My challenge is on the ground that it is a vague notice, my lord. No particulars have been given, my lord. What violation I have, only provision of law has been quoted, my lord, notice has been issued, my lord.
Yes.
And by this notice, my lord, my GST has been suspended. For that reason, my lord, I have not been able to make any business transaction, my lord. It will lordship will find second last line, my lord, the notice, my lord.
What was the earlier thing?
Earlier, my there was a proceeding.
What is that?
The allegation was that I have claimed input tax credit amounting to rupees.
Summary show cause notice.
Yes, sir. I have submitted my reply, my lord. Detailed reply has been given. They have not passed any order till date, my lord.
What was the
The allegation in that proceeding is that, my lord, I have claimed input tax credit around rupees, my lord, 3 lakhs and odd, my lord, from one of the vendor, my lord, who is non-existent, my lord, vendor, my lord. Against that, I have given my so-called reply, my lord. Reply has been submitted, my lord. Reply was
You
submitted.
reveals that you have claimed invoice supplies from Dhiren Kolita. 3,14,000.
Yes, my lord. The reply I have given, my lord. They have sought certain document. I have given documents also. That your lordship will find page 17, my lord. They have sought documents, my lord, which I have given already, my lord.
I
Page
have
17, my
revealed
lord.
input tax credit or so and so. Without a genuine irreducible that physical and detailed account is enclosed. Here it for your reply. So you submitted on 16/8.
16, my detailed reply was given, my lord.
These are annexes to the reply.
Yes, my lord. Page 19 is the written reply. And then, my lord, annexures are there, bills are there, everything I have given. Now they are pending adjudication this proceeding, my lord. They have issued this so-called notice at page 41.
What is 21 is, GST rules?
My lord, it is violation of section 16, my lord. Claiming input in violation of section 16, my lord.
Particular restrictions as may be prescribed and in the finance specified and sense. The critical input take charge and whenever shall be credited to the Yes, Mr. Jory, what is this? First, you issued a show cause notice to him.
Here, show cause notice.
Show cause notice. You asked him for personal hearing supported by documents. You said access ITC claim. Right?
Yes, my lord.
Then page 16, you have stated the figures and he replied. Right. This is under what? 142. A DRC 01 is issued when?
It was issued on 17.
Under 142A.
Yes.
Yes, my lord.
What is 142A?
Summary of so cause notice. Summary of so cause notice.
And violation of which provision?
Section.
Not to speak of main notice is not issued, perhaps.
No.
Then under what violation of which provision?
They have allegation of section 16 is violate, my lord.
Section 16.
Yes, my lord. I have not claimed the input tax is not eligible. They want to say, my lord.
DRC 1142A. Forty-two one. Maybe related to 73.
My lord.
Maybe related to section 73.
Yes, my lord.
Then you replied.
Replied, my lord. Now pending.
After that, 170, maybe 73,
My
I
lord.
think. Let us see 73.
Hello,
ITC wrongly claimed, right?
Yes, my lord.
It should be ITC wrongly claimed.
Yes, my lord.
Whether witness sought paid erroneously refunded or wrongly availed. Wrongly availed.
Avail.
Then so cause notice.
So cause notice.
Issued under service statement. Detailed service. The refer the service with the amount. So under section 9, the proper officer shall, after consideration of the representation made by the person, determine the amount of tax and issue an order.
Yes, my lord.
73-9, where is the order?
Lordship, here there are two proceedings from the documents annex. One is for access.
This so cause appears to have emanated from the previous proceeding.
But in my humble submission, two proceedings. The first is yet to come to an end with regard to the excess ITC claim. And here, Lordship, this page 41 was issued on 16/9/25.
How one can answer this?
Lordship, how one can, there is a provision for alternative remedy. It is within limitation. He could have availed that provision, Lordship. He has
so
not.
cause notice, show us which is the provision?
Lordship.
Against so cause notice, improper vague notice, which is the provision?
107, Lordship.
Appeal against what?
Any order or so called.
What is decision or order?
Lordship, any person aggrieved by any decision.
Decision or order? Where is the decision?
To Lordship.
Where is the
Since he is-
decision?
Lordship, he is claiming it's a vague, no ground. That's a good ground for him to make an appeal.
That is also a good ground to entertain a petition.
Lordship, then I leave it to your Lordship because there is an
Principles of natural justice.
alternative remedy, Lordship.
Violation of principles of natural justice.
But Lordship, there is a specific provision and remedy under the Act, and it is within the limitation.
Sir,
It is
decision.
Lordship, decision or order. The decision to, yes, Lordship, if it is not available on record, it will be automatically get
Show me
suspended.
any decision to issue so called notice is appealable.
Any decision, Lordship, it will,
Order is to be passed.
order
Order
in,
has to be speaking order,
yes, my God.
region order, right? We do not go into that category. Let us say decision. A decision to issue so called notice. Is it appealable? If you say I'll send him to relegate. I'll
Lordship,
relegate to him 107.
Lordship, going by the provision, it is appealable.
Appealable.
In my humble understanding, Lordship.
Okay, standing counsel says.
There is no provision, my lord. There is no provision in the act, my lord.
Standing counsel says a decision to issue because there is no final decision.
It is a decision to issue show cause notice. It is appealable.
No, my lord. Is it not?
Because on that also, Lordship, he has not submitted any.
Whether the
representation.
tribunal will go by your submission.
Lordship,
Whether tribunal will go by your submission.
Lordship, they may go,
Because-
they may not go. But in my understanding, Lordship, it's appealable.
If,
And
if
here,
you
Lordship,
say that there is precedent that a decision to issue show cause notice, vague show cause notice, is appealable under section 107.
Lordship, he has also not submitted any reply that there is no ground as to how.
Where, at least for, as a layman, you said two separate proceedings.
Two separate proceedings, Lordship.
So we remove this. Only we look at page 41.
Yes, ma'am.
What do we do? What if one receives a notice of this kind? What he'll do?
Lordship, if it is within limitation, it is because 3 months time is there. This was issued on 16/9. It is within the limitation. Lordship, he can go for it because it's a vague or
Yes,
whatever
Mr.
ground he
Vishwa,
can.
you contend it, you controvert it.
My lord,
A
section one.
decision to issue show cause notice is an appealable order. That is the standing council's submission.
Section 107 does not speak.
Otherwise, a show cause notice is not to be challenged.
Yes, my lord.
It is premature,
Premature.
otherwise. Law is settled.
My lord.
So,
I have relying upon judgment of Supreme Court, my lord. It says, my lord, when the so-called notice is vague, my lord, it amounts to violation of principle of natural justice, my lord. So paragraph 2 and 3, my lord. A small one.
perfectly fits the case.
But Lordship, here was their specific, Lordship,
Paragraph 3. Which ground is alleged against the assessee must be made known to him, and there is no scope for assuming that the ground is implicit in the issuance of show cause notice.
but Lordship, going by the paragraph 2, facts of the case, the SSC was issued a notice dated so-and-so to show cause why a penalty should not be imposed upon it under so-and-so rule. That's right, Lordship. And why central exercise should not be collected from it on
Paragraph
goods,
2, okay.
on goods cleared without payment of the same during the year so and so. Lordship, it's a
No, no,
specific allegation.
You read the last 4 lines of paragraph 2.
Rule 9(2) has been
No, no,
amended.
last 4 lines of paragraph 2.
The so-called notice does not set out any particular in respect of fraud or collusion or willful misstatement or suppression of facts or contravention with intention to evade the payment of excise duty. Not only does it not give any such particular, it does not even make a bare allegation. Lordship, but going by that, why should be so specific, Lordship?
We put this under suspension. You come up with something more. Because this is a decision to issue show cause notice is neither appealable nor normally in case of a show cause notice, a writ petition is maintainable unless something is made out. Now here is a case, simply you quote the provision, your thing is liable to be suspended, cancelled. Because you say it is a separate proceeding.
Separate proceeding, Lordship.
Good. Had it been same, then after an order is passed, this is a logical conclusion.
Yes,
That
Lordship,
show cause notice, his GST is liable to be cancelled.
Lordship, excess ITC, if it is continuation, then Lordship,
Because that is not decided.
That is also no decision has been taken and this is a complete as under section 29 and 30.
Standing Council, Finance and Taxation Department for the respondent number for all the respondents. Full stop. The petitioner was earlier issued a summary show cause notice on 17/7/2025 for the tax period April 2023 - March 2024 under section 73, GST Act. And the petitioner submitted along with Form GST DRC 01 on 17/7/2025, alleging inter alia that the petition wrongly availed input tax credit to the extent of rupees 3,14,085. So in response to the show cause notice the petitioner submitted his reply on 16/8/2025 along with documents to contend that the transactions referred to by the authority in the show cause notice were genuine, and in support of his such claim, he submitted documentary evidence, documents, full stop. Subsequent thereto, the respondent number 3 issued another show cause notice to the petitioner for cancellation of registration on the ground that the petitioner availed ITC in violation of the provisions of section 16 of the GST Act or the rules made there under by referring to Rule 21E of the rules. 69 question है Mr. Mishra and counsel for the petition has submitted that the show cause notice is absolutely vague as it has not given any details, and the petition is handicapped to submit any reply to such vague show cause notice. Full stop. Mr. Chaudhary Lanet, Standing Council, Finance and Taxation Department has submitted that the proceedings initiated by the show cause notice dated 17/7/2025 and a show cause notice dated 16/9/2025 are two separate and independent proceedings. Full stop. Insofar as the proceeding drawn by show cause notice dated 17/7/2025 is concerned, under section 73 of the GST Act, no decision or order has been passed under subsection 9 of section 73 of the GST Act as on date. And as such, full stop. It is further submitted by him that a decision to issue show cause notice is appealable under section 173 of the GST Act, and therefore the petitioner has an alternative, efficacious and statutory remedy of appeal. Full stop. Mr. Mishra has submitted, in response, Mr. Mishra has submitted that a decision to challenge a writ petition challenging a vague show cause notice is entertainable. Post of issue notice as all the respondents are represented by the Mr. Chaudhary, Learned Standing Council, Finance and Taxation Department, the notice is made returnable on 17/12. Full stop. Extra copies, 2 of the having regard to the submissions made by the Land Council for the parties and the contents of the show cause notice dated 16/9/2025. Comma, the show cause notice privacy appears to be the contents of the show cause notice. The show cause notice privacy appears to be vague. Full stop. In such view of the matter, comma, it is ordered in the interim that there shall not be any further proceeding in respect of the show cause notice dated 16/9/2025 till the return.
Well, small page, they must GST is suspended by this notice.
The show cause notice so and so shall be kept in abeyance till the return.
Item 51.
Let's do GST cancellation. Yeah, GST was cancelled because of non-adding the bank account, my lord. Subsequently, petitioner has made an application for adding the bank account. Lords will find the order at page 15, my lord.
Page
15 is the order.
Where is the show cause notice?
Page 14, my lord.
Where is 21D? What is rule 2010A?
That's non-adding of bank account.
It is an admitted position.
Yes, my lord.
Admitted position.
Yes, my lord.
Then
Then, my lord, I have made a
did you file any reply?
reply was not filed, my lord. But reply was not filed, my lord. Could not file. But page 16, my lord.
Undersigned based on the registration liability commercial. 21D. 21D. Let us see 21D and 10A. They are fairly set. 21D. What is rule 10A?
Furnishing of bank account.
Rule 10A. Subject to the provision of the application for approved. Relation showing the shall be subject to following characters. Okay, it is rule 10 capital A.
Capital A.
10A, 30 days.
30 days.
Within 30 days.
Within 30 days now.
Where is your registration certificate?
Page 11, my lord.
Page 11.
My lord.
When it was granted?
My lord.
13/6/2023.
My lord.
Then within 1 month you have to submit
My lord.
bank details.
My lord.
So, show cause notice. Now, what is the rule 21D?
My lord, it states that it can be cancelled, my lord, if the bank account is not been added, my lord.
Violates the provision.
Violates the provision.
Clear cut. Clear cut.
No,
provision.
my lord, subsequently, I made an application for adding the bank account, lord. You will find page 16, my lord.
So order is correct.
That's it is correct, my lord. I'm not, but I'm relying on judgment of Telangana High Court. Similar situation was dealt with, my lord, and court held, my lord, that, my lord, the only my lord, I'm relying.
So this appeal is also time barred.
Yes, my lord. Yes. Please time barred. Please time barred.
Now,
my lord, relying upon paragraph 10 and 11 of Telangana High Court. Similar situation, my lord. Similar case, bank was not added, my lord. Court held is not a major deficiency in saying that since subsequently it may be added, my lord. Court held that, my lord. Observe, my lord.
Yes, any circular is there. Your notification.
Paragraph 10 and, my lord, 11.
Where is the provision for late fee, etc.?
Rule 22, my lord.
Rule 22.
My lord. Sorry. Okay. Rule 23, revocation, my lord. This is my rule 23 sub proviso 1, 2, 3, fourth proviso, my lord. Rule 23, fourth proviso. Rule 23, fourth proviso. my lord.
Revocation of registration is cancelled by the provision on his own motion, me. That 90 days is gone.
Gone, my lord. Gone, my lord.
Fourth proviso, you say fourth proviso.
Yeah. Otherwise, time period is gone, my lord. There is no time period.
Yes, Mr. Jain.
Lordship, my
It is a case of leniency only. Nothing on law.
lord, nothing on. One thing is that there is no default regarding my lord that evasion and something like this, my lord. Only there is a default.
Right, right. But law is clear.
Yes, Lordship. That is clear. my lord.
You are done with.
Yes, my lord.
Under the law, you are
Yes,
gone.
yes, wrong. Yes, my lord.
It is a mercy now.
My lord, yes, this is a mercy. my lord. I want to revive my business, my lord.
May issue notice, Lordship, at this.
Huh?
May issue notice at
Take
this.
your instructions.
Lordship.
Notice. Not required.
Lordship.
Friday.
Friday.
My lord.
Take your instruction.
Lordship.
Otherwise, he is gone.
He is gone.
Or she.
She,
Or
Lordship.
Mr. R.S. Mr. Learned Counsel for the petition. And Mr. K. Jain Learned Counsel on behalf of Mr. S.C. Kyle, Learned Standing Counsel.
For respondent number 2 and 3, Lordship.
Respond number 2 and 3, Miss. Also heard Miss. Central Government Council, respond number 1. Mr. Joint has submitted that he will obtain instruction whether after cancellation of registration on that ground or not furnishing bank account details under Rule 10A, whether there is provision for revocation of cancellation of the GST registration. And whether any notification has been issued on the subject. Maybe there may be notification. Have you
I will
checked?
search. I have not found. I will search again, my lord.
Is the case on Wednesday? Maybe many things have.
My lord. Much,
Many such situations has happened.
my lord.
Find out any notification.
Much obliged.
Much obliged.
Timing method, item number 2.
Yes, Ms. Hazarika?
There is no chance notification regarding that application Lordship. Offline application also entertained Lordship. So he has already applied Lordship. So
Yes, he applied, but circle officer, he is saying circle officer sent him
the
back.
circle officer to do the needful within a stipulated time.
Let the matter be disposed of.
Yes, Mr.
Lordship.
I heard Mr. A. Narjari, Learned Counsel for the petition. Miss G. Hazarika. Standing Counsel, Revenue and Disaster Management Department. And Mr. S. S. Roy, Learned Junior Government Advocate Assam, for the respondent number
2 and 3.
2 and 3. Full stop. The petitioner, a senior citizen of 86 years,
Yes, Your Lordship.
has approached this court by the
yesterday petition on the ground that despite approaches being made with a request to issue with a request to furnish him a copy of the periodic patta of a periodic patta. The respondent authorities, more particularly the respondent number 3, has not paid any heed to it. Full stop. The case of the petitioner, as projected in the petition, is that he is the owner and in possession of a plot of land measuring 1 bigha, covered by tag numbers 99 and 100.
Yes, sir.
And periodic patta number 5, situate at which village?
It is Moza, I'll say Moza, Your Lordship.
There is no village.
Bander Dewa.
Huh?
Bander Dewa.
Where is that? Where is your patta?
Here, Your Lordship, the page 12.
Village Bander Dewa. Moza Kheras Khat, Narayanpur Revenue Circle, District Lakhimpur, subject plot for sought. First up, the petitioner further stated that he has been paying land revenue in respect of the subject plot till date, and also has also constructed a building thereon after taking a housing loan from bank. Full stop. The petitioner has further stated that in respect of the subject plot, he was earlier issued periodic patta in original for the period from, yes, sir, which period? It is mentioned there in the page 14. Okay. Nalage. Also. But he lost the original copy of the periodic patta despite best efforts. He could not retrieve the same. First of, in this connection, the petitioner had also lodged a first information report. Where?
24/6/2020.
Huh?
I could not annex the.
Where? At least you named the police station. You are not naming the police station also.
Lakhimpur PS, Your Lordship, because it's located in.
Lakhimpur, Narayanpur, lodged on 24/6/2025.
Local police station, Your Lordship.
Local police station. You don't name the police station also.
I apologize.
Whether it is registered or not, that is also not there.
We'll pursue it. Also.
Therefore, he submitted an application before the Respondent number 3. On 24/7/2025 to issue him a copy of the periodic patta. Poster. Projecting that the respondent number 3 has not given any consideration to the application, has neither given any consideration to the application nor has issued a copy of the periodic patta to the petition. The petition is before this court. Where is the petition? Post of Mr. Ms. Hazurika, standing counsel, Revenue Department, and Mr. Roy, the junior government, paying for the response number 2 and 3, have submitted that there is provision for issue of a duplicate copy of the periodic patta if the periodic patta holder is able to show genuine reasons for us for seeking the duplicate copy post of if the petitioner has submitted an application before the respondent number 3, then the writ petition can be disposed of with the direction to the respondent number 3 to give consideration to the application stated to have been submitted by the petitioner on 24/7/2025, and to consider his pair for issuance of a duplicate copy of the periodic patta within a reasonable period of time. The above submission, Mr. Najari, the counsel for the petition has agreed with the above submission of the counsel for the official respondents, in view of the broad consensus arrived at by the learned counsel for the parties in the stated manner, this footage of the view that instead of keeping this petition pending, the same can be disposed of with a direction to the respondent authorities, more particularly the respondent number 3, to give consideration to the application submitted by the petition, application was stated to have been submitted by the petitioner on 24/7/2025, before him on merits, and if the case of the petition is found to be genuine, then the respondent number 3 shall consider for issuance of a duplicate copy of the periodic patta on its own merits and in accordance with law. It is ordered accordingly. With the disorder, disposal of the writ petition.
Highly obliging.
In this case, very unfortunate. Writ petition arose out of the railway claims before the Railway Claims Tribunal. The claim was rejected, then we preferred.
What is the application?
My lord.
Implement.
My lord.
Implement.
And now we are on implement because writ petition was disposed of. Thereafter, it was discovered that there was a change because the claimant's farm was taken over by a company. So now whatever financial benefit they are entitled
Go
to get.
before the appropriate bench, I think. The bench is available or not?
Bench is available. Bench is, no, at this stage, my lord, it's a only question of implement. Notice may go at this stage because earlier we filed an application for modification and also for implement. Then this one court indicated that you have to file an application seeking leave. So today it has come up for the first time. Let notice go today. If they want to respond, they can respond in the meantime. Final decision can
Let it before the appropriate bench. This is, I think.
Then lordship may kindly mention, so that whenever it comes before the application.
Heard Mr. The written interlocutor application is preferred seeking implement of the applicant as the writ petitioner in WPC number 6303/2018, which has been disposed of by a judgment and order dated 8/5/2025 by a coordinate bench within bracket Likhibo Karda Ite J.
Honorable Justice Karda Kite.
Full stop. In view of the nature of the application, and then Council Board of Parties have submitted that the interlocutor application is to be listed before the appropriate bench within bracket Karda Kite J. Also registry to look into the case or into the matter and thereafter release the case before the appropriate bench. Karda Kite J. I think that will be best.
Yes, ma'am. Can it come on fifth
Of that,
nothing on merit otherwise.
Before another bench, huh? I think that is the proper course. All respondents are represented.
Yes, railways.
For at least items 6 and 7.
Is yeah.
These are two writ petitions where only one issue now actually survives, which is whether the attachment of the tea garden can continue. I'm also raising the issue whether the attachment was proper to start with. If it's proper, can it continue?
What is the case?
So the case is
So
that,
writ petition was prepared for what?
yes, there are two writ petitions that were filed, one in 2016 and one in 2017. I've also prepared a short written submission for your honor's convenience. So in 2016, there was a garden that was being run. That garden was in distress. Subsequently, there was a management change that took place. So the petitioners were the new management that took over the garden to try and revive it. Within 6 months of the garden being taken over, there was a meeting held by the deputy commissioner without notice to me, in which two orders were passed. One to take attach the garden, and the second to start proceedings under the Provident Fund laws.
No, when the cause of action started?
So in 2016, Your Honor. That's the first writ petition. But those may not actually be germane in today's situation. So that is why
Let us go to the sequence of events first.
Absolutely, Your Honor. So in 2016.
Yes, 2016.
The order that I'm impugning is dated
9/11/2016.
That's correct, Your Honor. That's the DC's order. That I'm
DC's
impugning.
order.
That's the DC's order. My case, Your Honor, has
9/11/2016 is page 190.
Sorry, 311, Your Honor. It should be a 3 or 11.
Let us go by the prayer first.
Please, Your Honor.
Page 18.
At page 15.
No, one by one, page 18. In the
So that will
prayer.
be the 2017 writ Your Honor is looking at.
Let us see page 18. Prayer.
Your Honor, is and which writ petition? I think that's the 2017.
3735.
That's 2017. Okay, very good, very good.
It is certified that the sum of rupees is due from whom believe against the arrears of so and so. With reference to the so and so. So there was a notice on
Yes,
9/11/2016 for Provident Fund use
Yes, Your Honor.
by the recover authorized officer.
Yes, Your Honor.
Okay.
So subsequent to the notice.
Then there was again 18/11/2016.
Yes. There was a demand notice.
There was a demand notice for recovery of 1,25,98,000 so and so.
That's correct.
Right? PF dues.
Now, subsequently, there was an attachment order, which Your Honor will find at page number 125.
125, order of attachment. that is 8-3. So these three are challenged.
Yes, Your Honor. Actually, the other two documents have also been challenged, but now it's come down to this because the attachment is continuing. And my submission is that the attachment is illegal for certain reasons that I'll lay out. So in this order, Your Honor may note one thing, that the order of attachment is for immovable property. Your Honor may note this. This will become relevant.
Order of attachment.
Yes, Your Honor.
Immovable property. Failed to sound so and so is treated in aspect of certificate. Forwarded by the so and so under 11A. The assignment is completed and after the state date. Why this
Yes. Now, Your
order
Honor,
of attachment is bad?
Your Honor may come to page 132. Now, in this, by way of this order, in the prior writ petition, the undertaking was given. In view of such matter, it is submitted by the learned State Council that no adverse consequences would follow.
No, there is state council. Whether at that time this PF authority is involved.
They were also.
No, they page 131.
So this is my first count.
That will not
Very well.
prevent.
Very well, Your Honor. So I'm assailing it on 6 counts. So that's my first count.
They are not parties.
Very well.
They are not bound by that.
I concede.
They are not bound by that.
I concede, Your Honor.
They are acting under the purportedly under statutory provisions.
Very well. So now we come to the statutory provisions itself.
Okay.
Now, Your Honor may go back to page number 125.
125.
And Your Honor may note that this attachment order is for immovable property.
Let us see 15B.
Yes, Your Honor. Your Honor, I have submitted a convenience compilation. Your Honor may have that.
This one?
No, that's my written submission. It's a thicker document with all the relevant laws.
Sir.
If Your Honor, I have additional copy as well.
Sir. Let us see 15B.
Yes, Your Honor. It will be it's the first document is the act itself. Then the act gets amended. So that will be at page 13 of my compilation. That's the amended act by which 15B is brought in.
15B
is brought in. Now Your Honor will find it at page 15.
Amount due from an employee in the rate includes the taken to finish 1.5. Payable under the check. Okay, 15B.
Now, Your Honor, the two things I would want to note here. Your Honor may have 15B1A, attachment and sale of movable or immovable property of the plantation or as the case may be
full
employer.
15B1.
Yes, Your Honor.
Where any amount is in area under section so and so any issue the below of this the certificate. The 15B1 within B2 certificate. There is
Subclauses A and C.
Specifying the amount. Area and regular on receipt for the proceed to report accounts specified from the employer. One or what's 15B1 small a.
So this says that you can either attach the property for sale or there can also be a management that can take place, attachment for management. That's C, appointing a receiver for the management of the movable properties of the plantation or as may be of the employer. So these are the powers that the recovery officer has. And now your honor may come to page number,
Let us see then 125 again.
is your honor,
125 again.
125 AE.
Okay, this parcel of land has been attached.
Yes, your honor.
Okay.
Not the business. There's no mention of the business in page 125. Because the business also gets attached and is handed over to the receiver, which is one of my points, which is my second point. So your honor may permit me to, your honor may come to page 57 of my compilation. I'll just then lay out the provisions in sequence. Page 57. And there's rule 2. Rule 52.
What is this? It is part of.
Yes. Now this is part of Schedule 2 of the Income Tax Act. Because the Income Tax Act, Schedule 2, as well as the Certificate Rules of 1962, both apply. That is where the procedure for the receivership and attachment.
This is income tax rules.
Yes, your honor.
It starts from which page?
It will start from page number
44.
44.
44.
Income Tax Certificate Proceeding Rules 1962.
Yes.
Yes. So 52 is where I would want to start. Says an order of appointment of a receiver under Rule 68 or 70 of the principal.
What is section 222 of the Income Tax Act?
Page 57, your honor.
Huh?
Page 57 of my compilation.
This is 52.
Yes, your honor. 52. The first one on top. Above part 8.
No, in your type copy, it is
Not type,
222.
not type copy. Your honor. My compilation won't be a type copy.
No, what is 222? In the order of attachment,
Right. Your honor is looking at
it
the.
is included in a property of defaulter by virtue of the explanation to subsection 1 of section 222 of the Income Tax Act. That attachment, this Income Tax Act rules,
Absolutely.
that is, if something is attached under the provisions of Income Tax Act, perhaps,
Yes, yeah. So what?
you cannot bring in.
No, your honor.
What is 222?
Yes.
Why he has referred to 222?
No, I'll just come there. Because actually the Act itself brings in these provisions, the income tax rule specifically and Schedule 2. I'll just come. Your honor, I have 1G.
By which provision
15G.
he has referred to 222?
Your honor, I have 15G. That'll actually make
15G.
Page 19 of my compilation, 15G.
15G. Page
19 of my compilation.
19. The provisions of second and third schedule of the income tax proceeding of 1962. As in from shall apply, which will due to state provisions of the truth. Areas were not maintaining section 82 instead of So this is this 15G by 15G, that income tax certificate proceeding rules 1962 have been by way of reference.
Yes, Your Honor. So those are the provisions that will now apply.
But
So
with
all,
such modification as may be necessary.
yes, and then the modification is SSC becomes employer. So I'm not, so this is actually the applicable rules.
Provided that any reference in the said provision or income tax act or rules to the word SSC shall be construed as a reference to an employer as defined in the act. Let me read 222. SSC, where an employee is in default or is deemed to be in default in making payment of, I don't think tax dues. The tax requires a drop and there is signature statement form specifying the amount of areas due from the SSC. Whereas a statement meaning certificate shall proceed to recover. Yes, 152 you are referring to.
Yes, Your Honor. So now, page 52 is at, Your Honor may find it at page 57, rule 52. Now, this is of the certificate rules. So one is the second schedule and one is the certificate rules. Both of them contain the procedure. An order of appointment of a receiver under Rule 69 or Rule 70 of the principal rule shall come in form XYZ, which may be so varied as the circumstances of each case may require. So the point I'm making is that there are two rules, 60 and 70. Now, Your Honor may have 60 and 70, which is at page 36.
No.
And these
the extent of Rule 15G, the provisions of the second and third schedule of the Income Tax Act and the Income Tax Certificate Proceeding Rule, as in force from time to time, shall apply with such modifications as may be necessary for their application to this Act, as if the provisions and the rules are referred to the areas of so and so. Give me the appointment of Now, Rule 222 speaks about attachments, okay, appointing a receiver for the management of the employee's movable and immovable property.
Yes, sir.
Now, is there anything with regard to receiver?
Yes, Your Honor. There is a receiver, respondent F. So actually, if Your Honor may have. Now,
Mr. Das. No, not the senior Das.
Junior Das, Your Honor.
Your prayer is limited to this.
Yes, Your Honor.
Right?
Yes, Your Honor.
So far as dues are concerned, first 119 certificate, right?
Yes, Your Honor.
By the authorized officer to the recovery officer.
Yes.
Then with a statement, thereafter issuance of a demand notice to you for the amount recovery. Thereafter order of attachment, right?
Yes, Your Honor.
8/3/2017. These three appears to be in conformity with the provisions of rule or the act, right? These three.
Yes.
And your challenge is to those three.
Yes, but subsequent events have occurred.
Subsequent, whether anything amended.
Your Honor, that has not been amended, but I brought it
Then-
on record by way of.
Then what is not challenge, what is to be done? These three are in challenge.
Very well.
That appears to be privacy in tune with the provisions of the act of that PF dues. So far, these three are concerned.
But
Then
the,
where is the question of appointing receiver?
the receiver was appointed and also impleted as a party.
In what situation?
Because the
Where is the receiver?
respondent number
Because
7
your, Mr. Das,
it actually comes to my yes.
Mr. Das, your writ petition ends at page 134.
Correct, Your Honor.
The challenge is up to that.
I concede, yes.
Is it not?
Yes, it is.
Then these three, if the challenge to these three fails,
Now the subsequent events that take place, Your Honor, which come
maybe a separate cause of action, sir. But these three dues were there. Then as per 15, the recovery officer, sorry, the authorized officer acted, issued a certificate. Recovery officer placed a demand. Thereafter, he ordered attachment. To that extent, you challenged it in the year 2017. So what are the illegalities in respect of these three?
The illegalities with regard to this, Your Honor, is the impugned or the undertaking that I had mentioned.
Undertaking that is not statutory and that is not binding for them.
Because, Your Honor, my once I have
This order is not binding for them. And anyway,
Your Honor, I have
in
the
any view of the matter, any undertaking given by state council is not binding, right? Unless it is Advocate General, right? So somebody has said, okay, it is an arrangement normally made. I don't take adverse action, but otherwise may not be binding. Any other order? What is this? Page 130? What is this?
This is the earlier order, and it's a sequence of orders. I'm not, because what had happened.
This is not material.
No, because the DC was given.
So how receiver has come into picture?
Because, Your Honor, in the counter affidavit, we learned that a receiver has been appointed. So, you know, I have page 19 of the counter affidavit of 4, 5, and 6.
4, 5, and 6.
At page 19.
Running page. Okay, their internal page.
I think it's in
19. Internal page 19.
Yes, Your Honor.
Yes.
Your Honor has the document appointing receiver.
If this is so, have you challenged that this receiver has acted
In my counter, I have
beyond his?
I have pleaded these issues, Your Honor, in my counter to this issue, because what's happened is Rule 70 is the one that's invoked in this letter. Rule 70 is immovable property, but if the clear lettering of the letter,
Rule 70 of the second schedule to the income tax.
which deals with immovable property, Rule 69 is business. And by way of this letter, take custody and manage the business/property is what's been said. And in the
But while you have challenged, just I have noticed, while you have challenged one particular.
Because there's sequence of events, Your Honor, that follow, because we subsequently learn that the receiver has actually paid all the money, the dues are paid.
125, that is of 8/3/2017. And this appointing receiver order is also of 8/3/2017.
We had no knowledge of this at that time. We only learned subsequently when they filed it. And finally, we get to learn in 2024, when the receivers implemented, that the monies have been fully paid by the receiver.
So it cannot be, they have filed the affidavit in 16 November 2017.
But implement takes place, Your Honor.
Huh?
The receivers implemented in 2017. Oh, sorry, 2024.
24. What did you do for last 7 years? This affidavit was filed and this fact was brought to your notice in 2017.
I don't want to speak for another. I was there at the moment, so I have no answer there. So would Your Honor consider giving me about a week's time to bring in these additional prayers? So the documents are all here and there is substantial justice to be done here because the money has been paid and the money has been paid.
So
as per
what
the-
happened thereafter? After attachment of the
Yes.
property, whether the property has been sold?
No, my lord.
No.
This receiver is managing the garden, my lord. Receiver.
Huh.
They should still there running the
years.
garden, my lord.
Receiver is managing the garden.
Garden.
Well, you have to say, if he has done some impropriety, you have to
believe he has.
challenge his action in a separate proceeding. I don't think this can continue for long. Otherwise, these three are okay. But 8/3/2017, the other order, which they have brought by way of an affidavit, as far back in November, if he is not managing well or he is violating the provisions of the rules or whatever these rules,
I come to know.
certificate proceeding rules.
Yes, Your Honor.
This you have to challenge in a separate proceeding. These three, otherwise these three are appears to be perfectly in order. You have challenged three in the petition. Is it not?
Yes, Your Honor.
Those three appears to be perfectly in order. So far as appointing the receiver, maybe within the law or may not be within the law. That is not an independent challenge. There is nothing. If after appointment, if rightly appointed, say, in exercise of power, but he has done some impropriety, that action is to be challenged in an independent proceeding. That is still under attachment, and this is going. That is whether these subsequent events, without any independent challenge, can be taken into account.
Your Honor, permit me to make the appropriate prayers because in my affidavits I have brought it in. I have challenged these actions.
For last 7 years, you did not do so. What is the affidavit? Let us see.
Yes, Your Honor. In my counter affidavit, which is at page 241. So this is my
Affidavit in
page 241, running number.
running.
It's my counter to the receiver's affidavit. So at page number 246, I brought in the challenges there. So this is what I'll have to sink or sail with.
Whether the role of the receiver has been outlined?
Yes, Your Honor, it is actually there. Your Honor may have.
In the act?
Yes, Your Honor. Your Honor may have. Your Honor may have page 55 of my compilation. Page 55. Appointment, power and duties of a receiver. So 48 deals with the powers of a receiver, remuneration, 50 deals with the duties. So this is where accounts comes in. And 51 then deals with enforcements of receiver's duties, which permits the RO to even conduct an inquiry.
This one shall furnish the security and the you to receive.
Receiver appointed as using all the powers. Bringing and defending suits for realization management. So, rule 48.
50 may be more relevant, Your Honor.
No, 48 is also, that is the power.
That's the power of the receiver. Yes.
So, has all the powers for realization.
Yes.
One,
Yes.
management,
Yes.
protection, and preservation of the property. So it is all
Not
embracing.
challenging. Yeah, I'm not challenging the fact that I'm not challenging that.
He is
these powers
managing,
exist.
and if it is a loss making unit, default making
Yes.
unit, then wherefrom he is not going to give his own money.
Sure, but that's
He
the
will
case.
manage and
It's to be generated from the profits and rents from of the
Whatever.
garden itself.
from the property.
And now what I see from the record is that they've been selling tea at 1.25 rupees and to 2.25 rupees per kg.
Oh, that is his action.
Yes, absolutely.
Huh.
The receiver is not is duty bound to check. Beyond that, the statement comes from you know, page 9 of the counter affidavit of the receiver, para 9. The receiver's counter affidavit. 176. No, not 176. 1 second. 205, I think. 204. 204. And para 9, receiver states that 1.25 CR, the entire certificate dues have been paid. Affidavit 19 lakhs. Para? Please. Then your honor may have page 196.
Yes, Mrs. Das, after suppose receiver is appointed,
Madam,
you are interested in recovering your dues.
madam,
Receiver is saying that he has paid the dues.
madam.
So thereafter, what interest?
No, actually, the amount is not fully recovered, my lord. That for that I will draw your lordship attention to my para 9 of my additional affidavit, my lord, at page 176. This additional affidavit had to be filed, my lord, pursuant to the order passed by this honorable court, my lord, on 3/10/2024, my lord.
3/10/2024. That is the order. 3/10/2024. Yes, what is the additional evidence?
Para 9, my lord, page 176, my lord. That the deponent begs to state that the receiver so appointed in compliance of this.
Para 9?
Para 9 of my additional affidavit, my lord.
176. Your honor.
176.
176.
6, my lord.
Running page.
Running page, my lord.
Running page. Para 9.
That the deponent begs to state that the receiver so appointed in compliance of the terms and conditions contained in the demand on the deed of agreement dated 6/4/2017 had already deposited an amount of rupees 1,6,6,872 against the recovery certificate amount of rupees 1,25,98,226, my lord, and consequent upon which a balance amount of rupees 19,91,354 is yet to be deposited by the receiver so appointed. Over and above, the appropriate balance amount of rupees so and so, 15% statutory interest shall have to be computed upon deposit of the entire recovery certificate dues, which will be recoverable from the receiver, which will then support. But this is my lord, pursuant to this or my information, my lord, that is letter dated 4/11/2024, my lord, which I have annexed as Annex G, my lord. On the basis of that information given to me, my lord, this additional affidavit was filed, my lord, that the entire amount certificate amount is not recovered, my lord, till now. That is up to 4/11/2024, my lord.
So after suppose amount and interest is recovered, and what will be the interest of the PF authorities?
No, my lord, if the entire amount is recovered, my lord, definitely the receiver will be removed, my lord, from.
Whether he has acted in terms of the deed of agreement?
My lord, that is that. But particularly only typically, my lord, after last,
You have entered into a deed of agreement with the receiver.
Receiver, my lord.
So what is the deed of agreement? Within what time? Because he has invested, he has managed, and he has been paying. So what is the, what kind of agreement? Because it cannot be for eternity.
That's actually the original agreement that is page.
Because he has, he may pay last 10 rupees, he may not pay. Keeping it pending.
No, in that case, my lord, if he violates the condition, terms and conditions of the agreement, my lord.
What is the terms and conditions of your agreement?
But that original agreement is I have annexed, my lord.
Yes,
that
please.
Page running page 190, my lord. There is a
7 years.
First agreement, my lord, which was
7 years gone.
My lord.
7 years gone.
My lord. That's the second agreement is executed, my lord.
Who is that?
The dates don't match. There's a 6-month gap between the end of the first and the beginning of the second.
That may be
2? 33.
The second agreement, my lord, that is for a period of 7 years, my lord.
12.
No, 12 years, sorry. 12 years, my lord.
12 years.
12 years.
So, in such a situation, what is the option, Mr. Das, for you? No. Otherwise, your challenges to these notices
Very well.
that are not subsisting. 8/3/2017, by which the receiver was appointed, thereafter a deed of agreement was executed for a period of 7 years for a dues of 1,25 lakh plus interest, whatever. Now here, which clause, by which clause now? By which clause for 12 years more? Huh?
Option is two. Clause two. And Lordship, this is clarification. The affidavit that the Durham Senior Council is relying on is November 2024. We filed in January 2025, claiming we paid the entire amount. And we annexed. Lordship,
In your affidavit?
Yes. We say so in paragraph 9.
Paragraph?
Paragraph 9, 204.
204.
Itu আমাকে কপি একটা দিয়ে আছে ইভিনিং কপি আমাকে কপি করে
Mr. Das, your any challenge needs to be on a different plank altogether. That 8/3/2017, if you intend to challenge initial that period, that deed of agreement 7 years gone.
Be that as
Now these actions, the subsequent actions, whether anything can be challenged, you have to find out. Otherwise, these repetitions And by this repetition, how can you challenge
Honour, give me
some
some time.
events which are taken place after 7-8 years?
I agree.
Right. So if initial period of 7 years gone by, now again they are entering into an agreement for 12 years. Whether these actions are assailable or not, you have to find out and
In my
make an
opinion, they
independent
are
challenge.
assailable.
But with this repetition, how can you continue this? All these are known to you now.
Yes. No, I've challenged it in the counter in my response to the.
How can you?
So Your Honour may consider giving me some time to amend, at least bring on these facts and amend my prayers, because otherwise it'll lead to
No,
multiple.
it is not a case of continuous mandamus and continuous pleadings. Is it a case that you go on filing affidavit, amending
Because, Your Honour, the fact-
affidavit, 7 years?
But the fact remains the amounts have been recovered. I'm out of a
That
guardrail.
is what I say, that I am saying that you have to think of making challenge on a different plank altogether. With these challenges to the 3 notices by the statutory authorities, I don't think your thing will survive. Subsequent actions of appointing the receiver, that has not been challenged. On the same date it was 8/3/2017. Thereafter, deed of agreement 7 years, that has also gone by. Then they have made a statement, this is the thing, whether by 12 plus 7, 19 years, the receiver can continue or not. Those are things which are to be, cannot be looked into in this petition, wherein the original challenge is to these 3. You have known every facts now. How can you continue this challenge and court will continue to entertain this
Very well.
reading?
I'll leave it to you on. I understand where Your Honour is coming from, and I agree.
I'm not finding it to continue any further.
And may give me liberty to pursue my alternative.
Yes, sure, but whether what kind of challenge you have to make?
Because actually the duties are on them, because as per Rule 50, enforcement of receiver duties is something.
Say if the statute provides for a
Yes.
period of duty for the receiver, is there anything?
No,
Or
there-
income tax rules?
No, there's no time limit given.
Huh.
But there are provisions that make it incumbent upon the RO to oversee the actions of the receiver and to make sure that the accounts are maintained properly. There's a whole set of laws that are laid out there. Quarterly reportings have to be done, but obviously that's not being done because.
That is, those things you have to challenge. That is fait accompli now, all these 3 taking over, appointing a receiver. Now, anything the receiver has done, any impropriety or illegality, after being appointed by a statutory authority, these are to be challenged on a proper basis. But these 3 challenges which in this repetition, that is old now, that has gone, has spent its force. Yes, Mr. Das. Not finding anything. Subsequent developments, if the receiver has done any impropriety or there is some collision and connivance between the authorities and the receiver, that are to be challenged. That is not challenged. How it is continuing, I don't know. You were originally in the repetition or you have come later on? So you are trying to restore the situation, but I don't think. Okay, we'll put it today so the other cases are there. We'll put it tomorrow. But pass the order.
Please.
But your challenge, you find out. If any challenge is possible to be made, point out, we'll observe in the order.
Right.
Dr. Only prayer is, they have not served us the counter
I will
affidavit by
absolutely
way of
do
which they are challenging me. So that was.
No, I apologize.
handicap.
I was under the impression it was done.
Therefore, the governments will not.
Fair enough.
We will not.
Absolutely, ma'am.
Thank you.
That is my error.
Didas.
Yeah, ma'am.
Petitioners. NC Das, Senior Counsel. Listed by Ms.
J. Bushra.
J. Bushra. For the
For,
response,
4, 5, and 6, my lord.
I'll say ATEPFO authorities.
Yes.
And we state, Mr.
7.
Mr. S.S. Roy, Learned Junior Government Advocate for the state respondents, and Miss G. Usami, Learned Counsel for the private respondent desk receiver.
Respondent number 7, my lord.
Respondents are in only one only.
7.
7.
Yes,
In the-
item 6. Item 6.
So that is why.
Yeah, yes, your lordship.
That is why state respondents, APTFO, and receiver. Release the case tomorrow. Anything Ms. Gusami to say?
Lordship, I'm the receiver. I hold in custody for the owner. They pay me, I can go up. The problem is they're not paying. The reason I came in is from 2006, there are dues. 2006 onwards, there are basic statutory PF dues, the extent of 1.25 crores, which is why there was an attachment, which is why thereafter in 2016, there was a meeting constituted. They didn't attend that meeting with all of the authorities. The management was given to DC, the administration. The administration is not equipped to run a tea garden.
No. Anyway, you were appointed by PFO authorities.
Our standards, we don't want to hold on to the.
Your role is under the PF authority.
We will go out when they pay us. We've incurred some.
Oh,
crores.
Mr. Das,
Yeah.
are you in a position to pay that?
Absolutely, Lordship. We
No,
are.
they are making a claim of 11 crores. Make a claim of 11 crores.
How to challenge it, right? Wage and means inflated.
Same amount.
Challenges.
You have to wage and means, but so far as challenge to this petition.
But the
is
law,
not survived.
the claims have to be made through the recovery officer. They cannot make a direct claim on.
You
me.
explore those
Yes,
things.
yes,
The law
absolutely.
is that you were supposed to pay PF.
Yes.
You explore
We're all
those things.
supposed to pay the PF.
Tomorrow.
Published.
Deeply obliged. Item number 9. Item 9.
You are for?
Respondent 4, lordship.
Respondent 4. So you are also sitting without finding any response.
Lordship, I'm appearing on behalf of my senior. He's out
He
of.
does not want to file any counter affidavit.
Yes, he's out of station, lordship. It was.
There is no representation on behalf of the petitioner today on call, full stop. Mr. S.S. Roy, Learned Junior Government Advocate, Assam. Okay, year amount of revenue, 1. S.S. Roy, and Mr.
Jet Dotto on behalf of A. Chaudhary.
On behalf of
A. Chaudhary.
A. Chaudhary. Learned Counsel for the respondent are present, full stop. None of the respondents have also any, has, none of the respondents has also not filed any counter affidavit. Full stop. In view of
We'll file
petition,
counter affidavit.
on behalf of the petitioner today on call, place the case after 4 weeks. Nobody is interested.
Item 10.
Lordship, my senior is Lex for the time. আমার সাইডটা আমি করে দিছিলাম।
So, if he is in legs, what to do by this court?
Your Honor,
Hmm?
my senior is Lex, Your Honor.
Right, if he is in legs,
Yes, ma'am.
what to be done by this court?
For the time being.
There is no representation on behalf of the petitioner today on call.
Can you pass over the matter for some time?
No passover. There is prayer on behalf of the petitioner as well as from the private respondents, from the respondent BTC authorities to defer consideration of the requisition first of in view of the state. Miss
Espal appearing.
Espal petitioner Lihiba and Miss
Jay Soikia.
will be the case after 2 weeks.
Obliged, Your Honor.
Item number 12.
Yes, Doctor. Standing Council. Panchayat Rural.
Yes, sir.
Yes, petitioner, Islam.
Sir, my senior thank is in another court, Lordship.
Whether you have got the houses or not.
Not yet, Lordship.
Whether it is in the list or not.
They
Call Mr. Doctor. No point if they are in the list, we'll close.
Right.
Item 13.
Also, we'll pass over the matter for time being, Lordship. And the Lordship here, in case he is coming, Lordship. At 2, Lordship.
Whether I have heard earlier.
Yes, Lordship. I think.
Then on some hearing day. Required to be disposed of. Some hearing day. Is already fixed. Can it be on 16th December? Tuesday.
Yes.
Tuesday. K. Colita petition. You were there.
Yes, sir.
16th of December. Because next week I will not be here.
Yes, sir.
Zigusami, respond number?
Four.
4. And standing council?
Sorry, Your Lordship, respond number 5.
5. SS Roy? 4. Huh? Finance?
16.
Who are there? Who are there? Or revenue, G Hazurika. 1 and 2. 3. 1, 2 and 3. SS Roy, 4. And Ms. Zigusami, 5. K. Colita. As for an agreed to, the executive on 16th, interim order. Continue.
Obliged.
Item number 17. Item 17.
There is no representation on behalf of the petition to be on call. Let the case come for answer justice to be listed after 1 week.
Item 18.
2 weeks.
I am for the petitioner efforts. This matter is a cancellation of the registration, GST registration machine. Last occasion says the department will get the time for filing the affidavit in opposition first. But
What is your showcase?
Showcase is page and page number 17. Annexure 2.
Your appeal was dismissed. Why?
Because some
Delay.
defaulter.
Delay in submission.
Yes, yes. But
Yeah, our cancellation or registration of an. What is the last page? Page 65.
65. Sixty-five is the
Standing council
order.
finance. Who appears? Otherwise, Mr. B. Borua B. Chaudhary. I think call Mr. B. Chaudhary. Standing council finance. After some time, every cancellation.
Sorry, my lord, in item 12, I was not there. I have received that instruction, my lord.
I got to.
Dada.
All are included.
Yes.
You get a, will give a copy.
Yes.
We'll close it then.
Yes, ma'am.
I heard Mr.
Yes, Hussain.
S. Hussain, learned counsel for the petitioners. Mr. S. Dr.
My lord.
Learned pending counsel, Panchayat and Rural Development Department for the respondent number 3, 4,
3, 4,
5,
5,
6,
6, 9
Nine.
and 10
10,
and 13.
13. Mr. S.S. Roy.
I'm for 3,
Junior.
2,
3,
no, Lordship, 2, 7 and 8.
2, 7 and 8. Mr. M.I. Hussain, learned counsel for the respondent 14 and 15. You have 12, 14 and 15. You have no cause of grievance.
Well, for once is appearing well.
Miss A. Fukan, learned Central Government Council for the respondent number 1. See, the petitioners, 5 in number. Had approached this court by the present petition stating that they are inhabitants of Tupamari. They are inhabitants within areas of Tupamari, Gaon Panchayat, District Kamrup. Full stop. It was the grievance of the petitioners that their names though earlier. Where is your representation? Though earlier included in the list of PMAY-Z beneficiaries, their names were dropped from the list in the year 2022. Right? Full stop. They preferred the petition seeking inclusion of their names in the list of PMAY-beneficiaries and inter area. Full stop. Para. Mr. Dr. Learned Standing Council, Panchayat and Rural Development Department has submitted that, on instruction, on instruction received from the respondent number 13, right?
Right.
Wide office letter dated 01/12/2025. Within bracket annexer marked and kept with the case record.
This was received from 10, respondent number 10.
Respondent number 10, as document X. That all the names of all the 5 petitioners have been included in a new AWAAS plus 24 survey of Pradhan Mantri Awas Yojana Gramin PMAY-G. Para, in view of inclusion of the names of the petitioners in the PMAY-Z beneficiaries list, there is no surviving cause of action to proceed further with the petition. Full stop. Mr. Dattov has furnished a copy of the letter dated 1/2/2025 also to Mr. Soel, so learned counsel for the petitioners. No serving cause of correction. Accordingly, the petition stands closed. তাৰপিছত এই কপিটো দি দিব তাৰ ওপৰ লাইন দি দিব
I love that one. Okay.
Number 19.
May I please, Your Worship? In this case, Your Worship, before going to the case, Your Worship, I would like to draw attention of this Honorable Court. This case covered by the Gunalata case. This case has been covered under the Gunalata versus State of Assam. But coordinate bench has passed order by citing the Shashi Sharma case, Your Worship. Apart from this case, Your Worship, my case is be dismissed. And
MSCT case, claiming ex gratia MSCT.
Okay.
so that case has been pending before the DB, Your Lordship. That fixed for hearing on 6th of December. So till outcome of this petition, maybe adjourn this.
Mr. Asayakan, learned counsel for the petition has submitted that issue involved in this petition is pending before a division bench wherein and date of hearing is fixed as 6/12/2025. He has just paid for listing on the case on a date after 6/12/2025. Justice Roy, and from an advocate for the state respondents is present. In view of the above submission made by Mr. Arthur, is the case on the 15th of December.
Lordship. So.
May it please your Lordship. Lordship, this matter pertains to land compensation. Herein the petitioner has already received the land and zero compensation, but the structural compensation went to a different person of having the same name. And this has been admitted in Kala's affidavit, competent authority for land acquisition, that is respondent number 5. If Lordship takes respondent number 5's affidavit, para 11 of respondent number 5's affidavit. May I read, Lordship?
Yes.
That with regard to the statements made in paragraph 18 of the petition, I say that as Probin Bora, son of Bhupati, refused to accept the land and zero compensation entitled to him, therefore land and zero compensation along with enhanced land and land value of Probin Bora, son of Rajani, was sent and deposited at the bank as per direction of the Court of Learned District and Session Judge, Land Acquisition, Rehabilitation and Resettlement Authority, Jorhat, White, LA reference case number 13/2022. Since the structure compensation was already received by Probin Bora, son of Rajani, instead of Probin Bora, son of Bhupati, hence the matter was then only to recover and to hand over the same to the right person. Steps for payment could not be initiated for direct payment of the same structure, that is, double payment to Probin Bora, son of Bhupati, of its own, unless an order of payment is received from the court. The Lordship will look at the queries that have been put forward by the court in an order dated 20.
Refused to accept. Entitled to. Who is the petitioner?
Petitioner is Probin Bora, son of Bhupati. We have stated in paragraph of our paragraph 8 of our petition.
Bhupati Bora. Why he refused to accept the land and Jirat compensation?
Lordship, at that point of time, since the structural compensation was given to a different person, so the land and but right, we have received the land and Jirat compensation now. So the amount of
enhanced land value.
Lordship, there is an order of this court which will make it clear.
Enhanced land value of Why it is written in line 4?
Yes, Your Lordship.
Therefore, land and Ziraat compensation along with
Lordship,
enhanced
at that point of
land
time,
value
at that point of time, we did not accept the land and Ziraat compensation, but there
Right.
was a
then
order.
therefore means what? Therefore, land and Ziraat compensation along with land value of Probin Bora, son of Rosni, was sent and deposited at the bank as per direction of the Court of Learned District and Session Judge.
To LA, there was a LA case that we had filed there.
Where direction was made?
In that LA case number, Lordship, it's LA case number 13 of 2022.
Where is that order?
Yes.
Direction of the Learned District Judge?
Yes, one sir. We have not annexed it in our writ petition, Lordship. Because
No, if it is Probin Bora,
yes,
was he also a beneficiary?
Lordship.
Probin Bora,
No,
son of
Lordship,
Rosni.
he had a different land in a different dark number and patta number, but since the name was same, Probin Bora, so
Right. He was also a beneficiary.
he was not a beneficiary of this land.
No, for another land.
For another land, yes, yes, for another
It is
land.
not that he is an imposter.
No. He was a beneficiary of another land, yes, sir.
Another land.
Another land, yes. Sir.
So it is basically a mistake.
It's a mistake of.
Now,
Distinct.
as per direction of the Court of Session Judge.
Yes, sir.
Where is the direction?
No, it's,
This affidavit states that
yes.
in LA reference case number 13 of 2022.
I have this, Your Lordship, but I have not. There is no. It's not annexed in the petition, but I have it in the.
No, if the direction is made
Your Lordship.
as per the direction of the learned district judge
Yes, Your Lordship.
to deposit
Yes,
that
Your Lordship.
amount
Yes, Your Lordship.
in the name of Probin
Yes.
Bora, son of Rosni,
Yes, Your Lordship.
then that is a mistake
No,
by
Your
the
Lordship.
district judge.
No, Your Lordship. That was only in lieu of the structural, the land and Ziraat compensation. The structural compensation was completely different.
Right, I have understood.
Yes.
But what is the direction actually?
The direction was only in the LA reference case number, the district judge had directed to pay the land and Ziraat compensation to the petitioner, which we were not accepting. After the direction was given, we accepted the land and Ziraat compensation, and in our affidavit, we have stated categorically.
See the meaning of this order.
Yes, Your Lordship, I understand.
See the meaning of this order. Land and Ziraat compensation along with enhanced land value of Probin Bora was sent and deposited at the bank
Yes.
as per direction of the Learned District Judge.
Yes, sir.
Wide LA reference case number 13/2022.
Yes.
And since structure compensation was already received by Probin Bora, right?
Yeah, this is the different Probin Bora, Your Lordship.
Son of Rosni.
Yes.
No, whether this structural compensation, this amount which the petitioner is now claiming,
Yes, Your Lordship.
it was deposited in the name of Probin Bora, son of Rosni, as per direction of the.
No, Your Lordship, no.
Huh?
That was
Yes, Mr. Roy.
That was no.
Lordship, as per affidavit, it was as per learning district and session judge rehabilitation.
Lordship would this
Reference
order
case.
of this court would make it clear, Lordship. There has been a Lordship right now is in the last order. The only question right now that has been put forward by the court is who is going to pay the structural amount, because they have admitted in their affidavit that they have wrongly.
1 minute. This is when it was directed?
Lordship, in the order dated is 23/9/2024 of.
Which order you were?
Yeah, Lordship, I'll just.
Date?
23/9/2024, Lordship.
23/9/2024.
Lordship, I've given a copy.
Here for an
Oh, Kala. Only 5 of instructions.
No, itu affidavit only distribute, he will take it. Push it, and take it.
Payment को लगो.
Itu.
You own how much land?
Lordship, I owned. Lordship, there are two.
Total. How
Total,
much
I
land?
own Lordship one.
1 katha 10 lesser.
1 katha.
And
2 katha 15 lessers, Lordship. 2 katha 15 lessers.
Two katha.
Sorry, Lordship, 1 katha 15 lessers, sorry, Lord. 1 katha 15 lessers.
No, 2 katha.
2 lessers.
Oh, yes, sir. 2
Paragraph
katha.
3.
2 kathas, yes, sir. Yes, sir.
Which land was acquired?
Lordship, Lordship, actually, both the lands
Adjacent.
are adjacent to each other. So they have acquired 1 katha 5 lessers of both the lands.
You are still in possession.
Yes, Your Lordship.
You are still in possession.
No, the land has been acquired by NHI.
Right, but paragraph page 12. Second para.
Lordship, if you, it is pertinent, Lordship. here we have
It is
state-
pertinent to mention.
It is pertinent to mention here in the on date. At that point of time when we filed this requisition, Lordship, that time we were in possession, but right now NHAI has already acquired this piece of land.
Who is for NHA?
C. Burua appears.
Oh, yes, Mr. Borua.
Lordship,
Lordship, in this case, records were called for Lordship by the last order. Lordship had not received. It was taken back, Lordship. It was given, then again taken back. It quite some time.
It is a 50 lakh something.
yes, 50 lakhs, Lordship, at the amount is 50 lakh 21,954, Lordship.
When it was filed, 2024. Yes, Mr. Borua, you have taken over the land.
Actually, what happened, these basic things, this one, as per.
Whether you have taken over the land.
Yes, we have taken over the land.
Taken over the land.
But
And response number 8, anybody appears for response number 8? Yes, madam. Huh? Who is your senior? So at the time of receiving the amount, you might have submitted indemnity bond. Yes, what is the procedure? Indemnity bond?
Yes, yes.
Is there any prescribed format?
Oh, your permit is there. There, file.
Yes, Mr. Roy.
It is to be submitted before the
Before the Kala. If indemnity bond is submitted, if something wrong has occurred, then you have to recover it as per the indemnity bond.
Actually,
But how the petitioner is to be deprived?
Yes, my lord, what happened, this case for.
He is a rightful claimant.
Yes, it was for a long time, it is when the only dispute is coming. He's also, petitioner is also claiming he's right. This respondent also is claiming that right, because though it is, we have paid to him, Kala has paid. Now, as per records are required, my lord. Record.
Assessment.
There is a record,
50 lakhs.
last occasion also record was called for, my lord. That's a records are required.
Record who will?
Well, government will produce. Kala will produce.
Lordship, on last two occasions actually.
Direction, again, record has been returned.
Return, Lordship. That's why pray for some
When
time.
can you obtain?
No, Lordship.
Next week, Lordship.
What happened, I guess, Lordship, on last two occasions, they had sought for instructions. The petitioner is right now suffering because the court has already observed that we are entitled for the money. It is the only question is whether Kala is going to pay or respondent number 8 is going to pay.
No, just because records were produced.
Yes, Your Lordship.
Yes, sir.
Right. This court was not seizing of the matter earlier. So I have to reach some
Your
privacy
Lordship. Yes, sir.
satisfaction.
Yes, Your Lordship.
It is not that I'll,
Yes, Your Lordship.
but if the indemnity bond is there in the record
Lordship.
of the response number 8, then obviously we don't know, whoever is the requiring and acquiring authority, they have to pay. Otherwise, and proceeding is to be drawn up for recovery.
Yes, that is the procedure.
But only thing is that whether existence of that estimation of 50 lakh is made in respect of the RCC building of the petitioner as per record. But by inadvertence, it has been sent to Proveen Bora, response number 8.
That is why, my lord, this, for instance.
Now you get the records, Mr.
Lordship.
Roy.
Next week, Lordship.
Lordship will fix a short date.
Next
Short
week.
date, yes, from
Next
which place?
It is from Jorhat, Lord.
Get the records. Maybe it is there in the office also.
No, Lordship, it has been taken back, Lord.
Taken back.
Lordship.
Okay. Mr.
Indrajit Bhuyan.
I. Bhuyan
Hi, Bhuyan.
for the petitioners. Petitioner. C. Borua, Standing Council,
No, 3 and
NHIDCL, 2 entries. G. Hazarika, Standing Council, Revenue, 4. Mr. S.S. Roy. Land Council for the respondent number 5 and 6. Any PWD? No. Miss. For the respondent number 8 are present. Mr. Roy has submitted that the records of the proceedings come after being returned on 24/3/2025, have been sent back to the authority. Post of para as the records regarding assessment of the structure in question and the manner in which the amount of rupees 50 lakh 21,954 was disbursed to the respondent number 8 are necessary for adjudication of the petition, Mr. Roy shall obtain and place the record on the next date of listing, first of list the case on. Yes, before.
11th, Lordship.
Before holiday, which
Lordship, 11th.
11th. But you can get it on 12th.
Yes, sir.
12.
12.
Much obliged, Your Honor.
Item 21.
May it please, Your Worship. In this case, my lord, I was supposed to file a reply, but could not, my lord. For its
Who is respondent number 6?
my lord. My lord, he is the my lord, he was the
What?
lessee who filed the writ petition earlier occasion. That is at page 144, 114, my lord.
What kind of prayer is this?
My lord, because we
Huh?
are in possession of the land, my lord. We are in possession of the land.
If it is a violation of some injunction order,
my lord,
if your eviction
my lord,
during the pendency of the suit
my lord,
is in violation of an injunction order of a civil court of competent jurisdiction,
my lord.
why did not you invoke
Now, that was
the
also,
appropriate provision?
that was also, my lord. They have evicted us.
Did you
from-
invoke?
Yes, that has been filed, my lord.
Huh?
That has been filed, my lord.
Where is the statement?
My lord, statement is there. Paragraph 9, my lord.
So what happened to that miss case of 2015?
That is also pending, my lord.
Huh?
That is also pending, my lord.
Pending.
My lord. My lord, pending.
And what prompted you to file this writ petition?
My lord, because we are earning. They are by establishing our respective shops.
Whatever, but this is apparently in violation of the injunction order.
My lord, when there is a apparent
Where is the writ petition order?
writ petition order is at page, my lord, 114. It starts from page 114, my lord.
Page?
114. And
40.
operation part is
And
from,
then
my lord,
114.
114. And operation part, operative part is at, my lord, page 117.
What is the suit?
My lord, suit for below declaration of right title interest and for permanent injunction, my lord.
Who is it?
That is at page, actually, my lord, suit starts from,
Pair.
my lord. The pair portion is at page 81.
What is section 7 IPC?
My lord, this is Court Fee Act.
Huh?
Court Fee Act, my lord. And paragraph 42, all the,
Come to page 82.
my lord, for declaration that plaintiff are entitled to.
Second prayer.
My lord, for declaration and.
Bedokoli case.
My lord,
And you want to say for not giving effect to notice under 18.2 and 18.3.
my lord,
Huh?
my lord, that was also challenged, my lord.
How can it be?
That was, my lord, by way of injunction, it was.
Who is the injunction?
Yes, my lord, at,
I think your suit is to be dismissed as not maintainable. But we cannot do that.
from page 105. That order starts from 105, my lord. And my lord, operative part is at page 113.
Mr. Roy, what are you doing?
Lordship, it was not,
112?
Lordship, it was not bringing to our notice.
Injunction was passed
Lordship.
on the ground that circle officer does not have the power to issue notice under 18.2.
Lordship.
And when there is a statutory amendment since
Lordship.
2010,
Lordship.
on that ground, they are enjoying the injunction order
Lordship.
and you are doing nothing. There is a statutory amendment already.
Lordship.
That circle officer has the power and authority and jurisdiction to issue notice under section 18.
Lordship, it was.
On that ground, and for this prayer, you have to approach that court. Prayer 1. Directing respondent authority to restore back the petitioners to their respective land till disposal of the title suit pending in so and so. That civil court has the power to do so.
My lord, even this honorable court may, my lord.
No. When one matter of
Or-
competence
Yes,
or
lordship, we put on what has done, my lord.
CPC. If that is done, if eviction is done, that is in violation of the injunction order. How can it be? There is no violation of this court's order. That court order is in
No,
violation.
this court's, my lord.
Then, are you executing court? Whether read court
But-
is an executing court that
No, not at all, my
they
lord.
will execute all the orders of all the courts.
Not at all, my lord, but where
None?
there is a, my lord.
Your very
disregard of the court's order.
occupation is in doubt. There is a Bedokoli case.
My lord,
Huh?
my lord,
I think civil suit is barred. Is it not?
Yes.
we should,
Settlement rules.
but when declaration.
It is going on since the last 10 years, it is a different issue. Altogether. Yes, Mr. Roy, why don't you give us assistance?
Lordship, I've seen Lordship.
Huh?
In our affidavit,
You
Lordship.
don't
we-
provide us any assistance. And we have to look for the rules and all ourselves
Lordship,
and look into
Lordship, in our affidavit, we have stated Lordship.
No, your affidavit is nothing. Question is about the maintainability of the writ petition.
Writ petition, Lordship.
That is what I am asking. Between two. CPC. Okay. Order 39 for disobedience.
Order 30 rule.
Rule.
One and two.
Disobedience to a Lord.
You go there, press your miscase there.
On Wednesday, I'll satisfy your lordship. Wednesday, this case may be fixed.
What more satisfaction? 100% satisfaction has been reached.
Only an opportunity, my lord.
Huh?
On Wednesday, I'll satisfy your lordship.
Wednesday will invite cost also.
No, my lord, because something I have found
Something
that
has to be, somebody has to be enriched at your cost.
on Wednesday,
You are 28 of you.
my lord,
How many petitioners?
28.
1,000 each. Will enrich the bar association by 28,000.
Otherwise, I have a case, my lord.
No case.
My lord.
On the Sahu, Mr. S. Sahu, and counsel for the petitioner has sought for listing of the case on Wednesday in order to address on the point of maintainability of the repetition, which has been preferred, seeking mainly a prayer, citing violation of an injunction order passed by Civil Court of Competent Jurisdiction in a title suit preferred by the petitioners as plaintiffs. Mr. S.S. Roy, and a junior government advocate for the state respondents, is in attendance. List the case accordingly on sworn.
Item 22.
Regarding land compensation, my lord, connected matter is fixed on my lord 8/12, my lord.
Why question of maintainability? Recorded. Let us see. They were initially informed by that the land being will be acquired by a negotiated settlement as per government notification. In terms of negotiation, and notice was published in the newspaper, which reflected the names of the petition along with their corresponding land to be liquidation by virtue of direct purchase. Subsequently, be evaluated so and so pass and allocated liquidation as so and so. And the land has already been liquidation. Full swing, till it. Affidavit file.
Yes, my lord.
Let us see.
That has not been tagged, my lord.
Huh?
Our reply has filed.
Affidavit file.
I have filed, my lord, on 21, my lord. That has not.
Potim Das. General Manager, Managing Director, APDCL. So where is the admission? Where is the admission to pay you 50 lakh per via? You said so, huh? Right?
But even, my lord, the admitted amount has not been paid, my lord. That's by instruction, my lord. Can it be on, my lord? 8, my lord.
When the court asks question, you seek adjournment.
He was arguing, my lord.
Yes, Mr. Roy or Miss
We have filed our affidavit.
Fukan?
Your
We have disbursed the money to the district administration, your lordship,
Ah,
4 lakhs per bigha.
so it is under Assam Land Requisition and Acquisition Act. Is it so? Competent authority. Who is the order of acquisition? Bismita Malakar. You are Bismita
Yes,
Malakar.
my lord.
Requisition and directed to surrender. Then after acquisition, what happened?
Now they have constructed the road, my lord, expense, my lord. They just the.
Change of rate on the basis of journal value to the tune of rupees so and so. And so and so. Moreover, the nearest land so and so. If your land has been acquired at 4 lakh per bigha,
Yes, ma'am.
and the nearest land is purchased by Star Cement at 40 lakh, right? You have a very good case for reference. Yes, why are you not filing, sir?
Waiting for instruction for lordship.
Your authorities are not responding to. You must file your affidavit. For your lackadaisical approach, this petition is pending. 7 days time only, without fail.
Without fail, 10 days.
Mr.
M Setia.
M. Setia for the petitioner. Miss K. Fukan, Learned Standing Council. AEZCL,
Respondent number 5
5 and 6 are present. Post of. The respondent number 5 and 6 has already filed its counter affidavit. Post of. But the respondent number 3 and 4 have not yet filed its counter affidavit. Post of. The same shall be filed within a week's time. Without fail.
Lordship.
Post of Mr. S.S. Roy, Learned Junior Government Advocate. Assam. Okay, PR Mohanto Likidi, Revenue 1 and 2. Appearing for respondent number 3 and 4 has undertaken to file the counter affidavit on behalf of the respondent number 2 and 3 and 4 within a week's time. Release the case on 15.
Obliged.
More than 10 days time.
Item 20.
But you must file.
Please, my lord, I'm appearing on behalf of Mr. M.E. Mondal. This matter has become infructuous because regarding the challenge to voter list of. Yes.
Mr.
S.S. Ahmed.
S.S. Ahmed, Learned Counsel, has appeared on behalf of Mr. M.U. Mondal, Learned Counsel for the petitioners, Mr. S. Dotto, Learned Standing Counsel, Panchayat and Rural Development Department for the respondent number 1, 2, 4, 6, 7, and 8.
Yes, ma'am.
4 and 7 I'm 4 and 7 I'm appearing.
4 and 7?
I'm appearing.
Okay, okay.
6 and 8 also I'm appearing.
Wrote and Dotto 1, 2.
1, 2, 6, and
6.
7. And 8.
6 and
6 and
8.
8. Yes.
A.B. Castro. Learned Counsel on behalf of Mr. R. Dubey, Learned Standing Counsel, Assam State Election Commission for the respondent number 3 and 5. 5. SS Roy, so and so, for respondent number 4 and 6. Okay. Third. Now, Mr. The counsel for the parties submitted that the subject matter of the writ petition is challenge to the delimitation process. In view of a judgment and order dated so and so. What is the date? Any idea? Common judgment passed in a batch of writ petition. The subject matter of the writ petition has become infructuous, as the Panchayat general election has already been held. So in view of the above submission made by Mr. So-and-so, learned counsel paying for the petition, the writ petition stands dismissed as infructuous, is closed as infructuous. Okay, Miss A.B. Castro. And we have the order passed today in the writ petition, comma, the instant interlocutory application stands accordingly closed. They have a IA.
Yes.
Obvious.
Your lordship, your lordship,
24-4.
regarding item number 22, can it be on 16? On 15, I will not be able.
17.
Oblige, your lord.
Item 24.
To challenge an order, look at it.
May I please, your lordship?
Yes, bank.
Lordship, matter may be taken after some time, lordship.
Yes, bank. Bank. Who is for the bank?
24 item number.
Huh? This is for what? Bank account. Oh, Lok Adalat. Lok Adalat. Who are for the private respondents? Madam, you are for whom?
Respondent number 4, 5, 6, and 7.
I've been asking for that.
Uh,
Do you have any intention to file any affidavit?
yes, kindly 3 weeks time may be allowed, lordship.
Okay, Mr.
M. Hussain.
Petitioners. SS P.R. Mohanto, Revenue 1, SS Roy, 2 and 3, and Miss?
4, 5, 6. and seven.
Name.
M. Teranpi.
M. Taranki. 4 to 7. 4 to 7. Okay, Ms. Taranki has sought for and is granted 2 weeks time to file affidavit on position on behalf of the respondent number 4 to 7. This is the case accordingly after 3 months.
25.
The writ petition, my lord, the maintained the core issue, the dispute between the two parties in respect to management of the academy, my lord. Lordship, just see for a moment, paragraph 12. They want to enforce the order of a civil division.
What is the case about?
Lordship, what had happened is that there was an injunction petition filed by us in the title suit regarding we being the society. Thereafter, the injunction petition was rejected, and then we approached this honorable court. The honorable court in its order dated Lordship,
Who are the petitioners?
we are the society.
You are a society.
23-10-24.
Society.
Yes.
Hmm.
So we are saying that we are the owners of the society. There's a dispute about their identity. So the injunction petition was filed, and we got the order in the under order 39 in the before this honorable court. Thereafter, we
Where?
Page
In this
30
petition.
page 31 in CRP.
CRP.
Yes.
39.
Lordship has got an except for
30?
31.
Or 31.
Possibly the operative part starts from 33. So pursuant to this, now the persons that are right now operating the account are not the persons of the society. So we approach Canara Bank because here the PAN card, the Darpan, everything regarding the school are in our possession. We approach Canara Bank saying that this is the position, this is the High Court's order. We gave a legal notice, and after this, we approach Canara Bank. Canara Bank told
Also from doing any private respondents, sorry, the respondents were restrained from representing themselves as president and secretary.
yes.
Tinsukia English Academy. And from in doing any prejudicial acts prejudicial to the interests of the applicant society. Okay.
So now the bank account is being operated, the signatures, everything is in their possession. Now we have the PAN card, we have the password, we have received income tax notices as well. So we wrote to the bank that like, because we are the real person, that there be an inquiry, because the bank account has to be operated by the person who is the owner of the bank.
Real person or not, that is not, has not been determined.
No, real person is not here. The question is that the PAN card is with me. Now in a bank account, what are the integral parts of a bank account? Bank account, the integral parts of a bank account would be, as per the KYC norms, would be the PAN card. The PAN card forms the basis of every bank account because this is, there is a direction of the income tax where the PAN card is the identification of the bank, of any bank account that is being operated is regulated only through the PAN card. Lordship, we have filed a provisional, the IT returns and everything has been filed provisionally because we are not being allowed access to the bank account. And in the Canara Bank account, there are deposits of more than crores.
Yes, Mr. Somaria, I am not filing any affidavit.
No, he has filed the affidavit.
Today we have filed affidavit.
It's not on record. So let it come on, because in this case, Mr. Kane Chaudhary is also there. Let it come on 15 for final disposal.
When did you file?
Today.
Today. What's it, can be after vacation if possible?
No, Lordship, 15th it may,
No problem.
maybe. I pray for 15.
15, that was the last week.
Lordship, because
Order
the bank
motion
account is,
No,
because Lordship, I'll show in the next thing that.
Put it on 12, thereafter we'll decide. But before that, because last week will be motion week,
Exactly.
subject to, we put it on 12. Before that,
12 will be Saturday.
Can it be in
no,
the
12
first
will
week of
be Friday.
Sorry, sir, Friday.
Madam,
12.
can it be in the
Friday,
first week of
Okay,
January,
Lordship,
madam,
12.
for final
Let it
disposal?
be 12.
Can it be in the first week of January, my lord, a final disposal?
No, Lordship, let it be on 12. We'll try on that day. Let it be on.
Motion.
RJ does for the petitioners, Mr. Somorial and council for the response number. Response number 1 to 4.
I'm, my lord,
The
7,
bank
I'm
gives the-
representing 7, man.
Huh? You are Canara Bank or
No, my
No,
lord. I-
Canara Bank is not.
who is for Canara Bank?
Canara Bank, I think the council is not there.
Huh?
Canara Bank council.
I'm applying for 5, 6 and 8.
Item number
5, 6 and 8 is
25. Standing council Canara Bank. Who is standing council?
Mukesh.
Canara Bank?
Mukesh.
And without the assistance of the bank, how?
That is he has to be there. He is the main person who is.
And
there.
he is the main person, at least he
So-
has the,
So
he has the record.
he has a record and he has a Lordship. Just
Lord,
may
the
give a
bank stand is, my lord, bank stand is that because the dispute is going between two group, my lord, therefore, my lord, the existing
Be-
position.
He is in between the correspondence, not before the court.
court. That's what they. That's
Mr.
My lord,
Moria,
the-
please understand, it is when the communications are between the parties,
That's a
then
different-
bank has made the
the
stand.
bank has made the.
But bank has to make the stand before this court.
Yes, absolutely.
If that is the way this proceeding is to be this adjudicated and everything, all documents, internal
Yes.
documents will decide.
Decide that.
Well, what I'm
Very
saying,
good,
my lord,
wait.
Lordship may fix it on 12 with an observation
Let
saying that
Mr. Sharma come. Mr. S. Somoria, that's 7. Yes, where is Mr. Bank?
Lordship, Mr. Sharma's legs before undercoat, Lordship.
He is always on legs. We find that he is always on legs. Mr.
Hey, how are you, my lord? 5,
How are you? For the respond number?
5, 6.
Full stop. It is submitted that respond number 7 has already filed an affidavit in opposition. Full stop at the same affidavit in opposition from record. The please to bring the said affidavit on record. Full stop. Miss so and so land council for the respondent number 1 has sought an adjournment of the full stop. On the ground that Mr. M. Sharma, standing counsel, Canara Bank, has inconvenience today to appear at court today. Release the case on 12.
An instruction may be brought from the bank regarding the.
Lordship, can it be on 15, Lordship?
11, 12.
Lordship, he will not be available.
Item 26.
Then we'll record his absence. We'll record his absence.
Deeply obliged.
I may appeal, Lordships. In this case, my lord, respondent number 9, 10, and 11 and 12, my lord. And they are functioning as a president and vice president, my lord.
Oh.
But, my lord, as per section rule 46(3), in violation of 46(3), my lord, the election was held between the four ward members. Out of 10, my lord. Out of 10, my lord, 6 are absent, my lord. Only 4 present, my lord. Oath taking, my lord. And thereafter, my lord, election was between them, my lord. And declared them as a president. and vice president.
What happened? Please, story, please. These petitioners are what? Elected members?
Elected.
Okay, 4 elected members. And who are the rest 6?
All are elected members, mother. I'm sorry, mother. All are elected members.
Petitioners are elected members.
The others also elected.
And private respondent 9 to
9
to 12.
11, 12. They are
9 to 12. Where are the remaining 2?
remaining 2 disqualified, but stay is there.
Stays there.
Stay.
Okay. Now what happened?
Now the question, my lord, your lordship kindly see, election held on 7/5/25, result declared on 11/5/25. Then your lordship certificate also issued 25/25, certificate issued. Then first notice by the election, your lordship kindly 2 things are there. So far quorum is concerned. One quorum is for the elected, once government is constituted. Another is for the purpose for constituting that my lord. What is it? So now the first notification to hold the meeting for oath as well as for my lord election of the president and vice president.
First meeting.
First meeting, madam. So
Which,
page 33, your lordship, page 33. Page 33. Yeah, that was my 16/6/25 meeting to be held on 23/6/25. Your lordship got it.
Following authorized to administer. Page 33.
Yes.
Which is your Gram Panchayat?
This is Gaon Panchayat, our Gaon Panchayat is my lord Dumkura.
Serial number? Who is the officer? Page 33 is a notification of
Yes,
16/6.
Yes, I am serial number my lord 6.
6.
6.
Which Panchayat?
This is Panchayat Dumkura, your lordship, page
40. Dhumkura.
40 Dumkura.
Dhumkura?
Yes, ma'am.
Okay.
So our meeting to be held on 23/6/25. First date, ma'am.
The following is authorized to administer the oath. So, to administer the oath
Oaths as well
of
as election
appropriation and conduct of election.
of president and vice president.
Right. So 23/6/2025.
First. Meeting
Right.
not held.
Meeting?
Not held. On 23/6/25 and held postponed to 3/7/25.
Sorry.
Then kindly say page 35.
First meeting postponed. and first meeting will be held. On 3/7, it is declared that
No, 3/7, page 35, it
Ah.
says, my lord, meeting could not be held due to unavoidable circumstances.
first meeting will be held as per so and so. First meeting is postponed. And Mr. Vote for post. Okay.
Then it was.
It was 10/7/2025.
10/7/25. 10/7/25. This is the first meeting ultimately made. Only 4 members present.
10/7. 4 members present.
There are 4 members. Petitioners 4 and plus 2, and 2% disqualified prior to the date of my lord, that meeting. What did you say?
Prior to 10/7.
Prior to this, immediately 1 day prior to that, Yemen.
Okay.
That's why they are got it delayed, my lord, just to make. Your lordship knows the internal politics, my lord. They wanted to get president. If 2% remain, the majority, they become majority petitioner side, my lord. They remain only
2 were
4.
disqualified.
Qualified 2 other elected persons, my lord. That case is also pending, that is also stayed.
No. Here, Gram Panchayat normally has 10 members.
10.
Right?
Right.
Then on 3/7/2025, it was notified that first meeting will be held on
Yes.
10/7/2025.
Right.
On that day, 2 things would happen. One is oath, second is
Election.
of president, vice president.
Vice President.
On 10/7, how many were present?
Only 4.
Only 4 were present.
Respondents were present.
Okay.
And meeting conducted and they have, my lord, selected.
Now what is the law?
Law. Now law kindly see page 43, 46, 3.
No, whether now for what it has come? Nobody has filed affidavit.
Enough time was given, your law kindly see date.
Huh?
My lord, lordship may kindly go through the say section 46, rule 46, my lord.
Yes.
It will clarify everything, my lord. Yes. Because the only grievance is that quorum was not present. Hold on, sir.
My lord,
After completing.
46, my lord, rule, my.
Yes.
Yes.
Now where is the provision for oath of affirmation?
Yes.
Just for my knowledge.
Oath 134.
134.
Yes. Page 145, if this is the book, my lord.
Page? This one.
Yes.
135.
145.
Okay. And in the act, where is the meeting for first meeting?
This is the 10/7 is the first meeting, man.
No. The section.
For section 134, taking of oath. your
That is your oath.
Every person who is elected.
That I have read.
Section 10, my lord.
Section 10.
Or section 10, yes.
Oh, this is new one.
Yes,
Earlier, president used to be directly elected.
yes.
After the election of the
This is.
elect in the manner prescribed. We had is 50%. No, section 6. 3, sir.
Yes, Gaon Panchayat.
You are standing council,
Yes, sir.
Panchayat.
10 for.
6/3.
Yes.
So that is first meeting.
Yes, first one is
Okay.
10/7.
Okay, now rule.
Now 46. 46, page 213, your worship.
207 in my book.
46 rules.
46 rule?
Yes.
207 perhaps.
This book's 230. This is different book.
This is 25 my lord. Amended.
No, এখন 2025 কিতাপ লৈছে।
Thereafter also amendment was done by.
My lord, we are having extra problem.
25 or initial stage of it.
একটু ফসল দুটা বলেছি আগে এটা বলবো
June, 28th June after amendment.
July.
Page
2G1,
213.
213, 46, subclause 3, my lord, page 214.
Clause 1B of subsection 6. Another provision. Wrong. This provision is wrong itself. Where is clause B of subsection 1 of section 6? There is no provision.
6, section 6.
C.
Oh, yes.
C, where does it? Clause B is there.
This books, my lord.
Then this is also wrong. This book is also incorrect.
That is actually there to say, my lord, it is approved by them, my lord.
Earlier was correct. Yes. By causing a written notice specify the time. 7 days before the date so fixed. Shall be presided over by so and so as this case may order the administrator oath of affirmation to the as per section. If 1/3, yes, which clause?
Now 3 your lordship.
If 1/3 or more, the members called to the meeting some are not present within an hour of the time fixed for the meeting, as the case may be. When the earlier, why the earlier meeting was adjourned?
They said, my lord, due to
23,
unavoidable circumstance, page 35. Page 35.
What is unavoidable circumstance?
That is, they can say, my lord.
Huh?
Only they are the person who can say.
Maybe he may fall ill. Authorized officer.
Maybe, my lord.
Huh?
I don't have an instruction to that man.
When we have practiced that, it was not held.
Huh? Who authorized officer? See, I am correct.
Your lordship will correct, my lord.
My guess.
We do not find, my lord.
My guess was correct. Then it is not first meeting then. The second meeting is not adjourned meeting.
Yes, but all the meetings they call first meeting, my lord.
My lord,
All the meetings are first meeting.
No.
I'll submit mine.
1
As per
minute.
constitution.
Unavoidable circumstance.
Yes.
This is this ACS, Mr. Pranjal Barua. He fell ill on 23/6. What is your leave application? Who?
This was fine.
नाम क्या है?
Lahori Ghat.
But here it is, my lord, Vikas Chatri. Officers, page 33. Your lord's kindness, page 33.
I have seen.
6,
I have seen.
page 33. Vikas
It is-
Chatri.
What is AL? He's CO.
Yes,
Circle officer.
CEO, Lahori Ghat Revenue Circle.
Huh.
Then 346, there was another notification where Pramod Sharma.
Okay. Pramod Sharma, maybe.
We don't have that.
Then No, no, on 23/6, why it was not held?
Because of medical issues, my lord.
To Vikas Setri.
No, my lord. The second one, my lord.
No, but meeting was supposed to be held on 23/6.
Yes, my lord. Ekon,
Leave application is subsequent,
my lord.
is it not?
Yes, but there's a notification before 6:25.
Yes, after that.
Mohit Sharma.
Please hand it over. 16/6 to 23/6.
I didn't say issue. Am I wrong? Mr. Gomba.
First meeting was on
I don't know how. 18th month.
your Thumkara.
My page 33, Tumkura, Lahori Ghat. Page 33 is very.
First meeting was on 4/7/2025.
We are having matter on 3/7.
4/7.
Page 33. Maybe madam. Record may be correct, we may be wrong, madam.
First meeting around 10/7. So what happened on 10/7?
10/7, 4 persons present among themselves, president, vice president, vote taken.
Now, what will be the number of
Your three says, madam. Suppose 3.
you according to you, how much, 10 or 8?
Minimum madam must be 6.
No, total, if one has been disqualified, 2, by whose order?
Who disqualified my lord?
By whose order?
By DC's order, madam. That was challenge.
That was silly, no. On 10/7, prior to 10/7,
I think we say disqualification.
when the disqualification order was passed,
Yes. Disqualification is, my lord, 2% Golna so and so disqualified 2/7/25.
2/7.
2/7.
And stay order?
Stay order is WBC 13/8/25.
So on
In between.
10/7, 2 were already out.
In between, right.
Right. So 8.
Right.
8.
Right, 8.
8.
8.
What is 1/3 of 8? 3.
Out of 1/3 will be 3.
3. 1/3 or more of the total number.
My lord, otherwise also, my lord, for 10, my lord, 4.
Huh?
For 10 members, my lord, 1/3 is 4. 4 already
No,
present.
he says 2 are disqualified.
My lord, in any case, otherwise also.
10 members, my lord, may be disqualified. 10 members, they have to be called.
Then
My lord, you disqualify, let them come, you reject them here, my lord. That is another aspect, my lord. But your lordship, 10 members, your lord can see if 1/3, your lord kindly see the wording, my lord. 3, surplus 3. If 1/3 or more of the total number of the members, 1/3. So 10 members total.
3.33. So it is equal to 4. 4. So you, according to you, it ought to have been adjourned.
Adjourn. Adjourn because cannot be, quorum is not there, my lord. Quorum is not there. This is my case. 1/3, if 1/3 you have said, 1/3
Not
means
present.
4.
Meaning that by 4
4.
are absent.
Absent.
Then on that day, the meeting had to be adjourned.
This is my case.
Submit now?
Yes, yes, yes.
Yes,
why
my
not?
lord. I am reading it
Full
again,
name,
my lord.
full research.
I am reading it again. If 1/3 or more of the total number of members called to the meeting under sub-rule 1 are not present within an hour.
Within an
My
hour?
understanding is that, my lord.
Within an hour?
Yes. If 4 are present, that is sufficient.
No, are not present.
Yes, my lord.
Then what is the consequence?
1/3.
You cannot read.
Yes, my lord.
Read further.
Yes. The deputy commissioner or the sub.
If 1/3 or more of the total number of members call to the meeting, let us assume for a minute 10.
10, yes. I'm also.
Are not present.
Yes. within an hour of the time fixed for the meeting.
Hmm.
My understanding.
Now, on 10/7, for whole day they were not present. Four.
Yes, four were present.
No, no,
Or at
it
that-
is,
on
are
that-
not present.
My lord, this is saying, my lord, that if
Meaning thereby, if it is 10, 1/3 or more are not present, whether it is causas omissus, we don't know. But this book is correct or not, I do not know. I have not seen the Gazette notification. 4 are not present. 6 are present. What the Deputy Commissioner will do?
then postpone,
Postpone.
only option.
Postpone.
Yes.
Then he cannot elect.
Yes, now only question is, my lord, the interpretation whether 4 or 6.
Not 4 or 6. Then it will
Requirement.
come
the
down
quorum.
more. If it is 8, what will be 1/3?
3.
3. 3. 3 are not present. Petitioners are themselves how many?
My lord,
4 were present. 3 were not present. In fact, 4 were not present. Then what is the option?
my lord, my understanding is, maybe I am wrong, my lord, subject to correction, my lord. The venue, my lord, after fixing the date and venue, my lord, this rule is saying that minimum 4 need to be present.
I did now see the notification. Before that, first meeting.
Yes, sir.
Had it been second meeting, yes.
For second meeting, there is no quorum.
For first meeting,
Yes.
if 1/3 or more, 1/3, let
Yes.
us,
Yes.
no confusion, 1/3
Yes.
is not present.
On that day,
First meeting, first meeting.
first meeting, yes.
He has to adjourn.
But on that day, 4 were present, my lord.
What question is 1/3?
Yes, 1/3, 4, 10, for 10,
If-
my lord.
On the first meeting, out of 10, 4 were absent.
My lord.
He has no other option but to adjourn.
That is the only thing, my lord. Petitioners are saying, the lordship is saying same, my lord. But my understanding is that it's saying, my lord.
Where is that? He
requirement
can
is-
proceed. Where is that? He can proceed with the meeting. Where is that?
My lord,
If something is not there, only option is that he has to adjourn.
my lord.
Shall adjourn the meeting pending fixation of another date by the Deputy Commissioner as a given not later than 15 days of such meeting. Now next.
This rule is actually little bit confusing, my lord. Because if 1/3 or more of the total number of members called to the meeting, sub rule 1 are not present, I think there is a hidden word that on that place. That will clarify.
How
my
can, how can you, how can the court put an word in a statute?
My lord, that is
Huh?
why. That my understanding is I was reading as, my lord, that 4 is the requirement.
4 is, if 4 is 1/3 is absent,
In fact,
meaning thereby 2/3 is present.
In fact,
That will not be quorum.
in fact, for general meeting also, section 18 is saying 1/3, my lord.
It is different one.
Yes, that is why I am saying general, for general
It is
meeting.
different. After constitution of the point.
Yes, that is a general provision, my lord, general meeting.
That is after that.
That is a general for general.
For meeting. But here is a question of electing the president and vice president by a democratic
Yes,
process.
yes, yes. Yes,
And
my lord.
if 1/3 is absent or more, then he should not do. It is, yes, it is not a case of the petitioner that they did not
Receive the notice. Yes,
Despite receipt of notice, they did not do so. Suppose another meeting.
yes, that is, yes.
Another meeting is held, adjourned.
My lord,
After they did not appear, it is their choice.
my lord,
And deputy commissioner can go ahead perhaps,
my
because
lord,
it is not there.
my lord. Lord, therefore, lordship, for interpretation of this rule, my lord, the government's affidavit is important, my lord.
What government affidavit?
My lord, this
Whether Mr. Roy is going to file any affidavit.
Lordship. It's gone for waiting, Lordship. Paragraphs for waiting.
Is it?
Lordship.
From secretary?
For Lordship. Because gone for signature, Lordship.
Through whom?
The deputy.
Deputy commissioner is not going to
yes, my lord. Lordship may
interpret
grant some- my lord.
the rule perhaps. Only thing is, I think, where is the section? In Assam Panchayat Act.
Which one?
Section 6. is there.
Constitution.
No, if anything is
That's okay.
required to be
Or
interpreted,
11,
it is the government.
section 11.
No.
We have also submitted a appeal, my application before the DC on page 38, your lordship, my page 38. Section 11, my
Oh,
Yes.
that also you have done. Nothing has been done to do. Any dispute relating the validity of the election of the president, vice president, appointed under this act shall be decided by the deputy commissioner. Section 11.
yes, it is there.
And-
This is for dispute regarding, my lord, election, not
This is-
interpretation, my
this is
lord.
the dispute.
Validity of election.
Yes,
Validity of election.
validity of the election we are challenging, man.
Validity also.
Yes, validity also.
Where is the question of interpretation?
Yes, the
It is clear.
law is very clear, man.
Deputy commissioner need not have to file affidavit. He has to decide
Yes.
My lord.
within 7 days.
Already 3-4 days they have taken.
No, to decide.
Yes.
To
That,
dispose
that,
this.
To decide.
yes.
He
Page-
is not required to file any
On page
affidavit.
38, our appeal.
He need not
Yes, ma'am.
required to file affidavit.
Yes, your lordship may
My lord.
dispose in that right also.
Because rule 46(3),
Yeah.
40.
What is this thing?
there is, if he interprets it differently, then you come before it.
Right.
I think that is the issue.
My request, please. Page 38, just my appeal, man.
Yes. He has to get the
Oh, yes, fine.
opportunity and audience.
What are you start?
Lordship, our affidavit is almost ready, Lordship, so
No, what affidavit? Facts are admitted.
Lordship may dispose of indirectly.
Facts are admitted. Mr. Ahmed, you are,
By proxy, my lord.
One thing, Lordship, I want to, my lord, even if my lord, second, my lord, meeting is my lord adjourned, Lordship, that may not be my lord, after 15 days, more than 15 days, Lordship.
no,
Even
notification
then,
is
that,
clear.
my lord, the petitioner cannot
Notification
claim,
is clear.
The issue-
First meeting. 10/7 is the first meeting.
my lord.
Somebody fell ill, then this authorized officer has been changed.
That is why, my lord,
Because
second
there
meeting-
was no meeting at all.
my lord, there, if the meeting was even then, it was, my lord, my lord, postponed, Lordship. Even then, my lord, petitioner has no claim because she was not a member within 15 days, my lordship.
What?
Maximum period is 15 days, Lordship, for adjournment, Lordship. Even from the date, my lord,
Sir,
of that meeting,
there was no adjournment.
my lord, that is why I'm
There was no adjournment. That was the first meeting.
Lordship,
Had it been second meeting,
no, Lordship.
Yes.
Mr. Chaudhary's petition, I would have dismissed it. I would have dismissed it.
I would have considered, man.
Lordship,
I would have dismissed it.
Yes.
it may be directed to be disposed of, Lordship.
Mr. Roy, who is the deputy commissioner? from
Without any,
business?
my lord,
My lord, may I leave, my lord?
Yes,
Please, you.
I heard. Mr. H.I. Chaudhary, Learned Senior Counsel. Estate by Mr. A.M. Ahmed, Learned Counsel for the petitions. Mr. Doctor, let him decide, thereafter we can interpret.
My lord. In the meantime, I'll try my best.
my lord, without, my lord, commenting on merit, Lordship.
Who will represent, okay, Mr. S. Doctor, Learned Standing Council, Panchayat and Rural Development Department. For the respondent number 1,
My lord, for
Four.
1, 4,
4,
7, 8,
7,
and 8.
8. Miss PB, AB or PB? AB, Karastal Learned Council. Representing Mr. R. Dubey, Learned Standing Council, Assam State Election Commission for the respondent number 2. Mr. S. S. Roy, Learned Niyagam Advocate, Assam for the respondent number 3, 5, 6. 3, 5, and 6. And Mr. M. H. Ahmed,
Formal 9, 10 and
Learned
11.
Council for the
9,
respondent
10,
number
11, 12. 9, 10, 11 and 12.
9, 10, 11, and 12. Full stop. Para. Portion 2. A notification dated 2/4/2025 issued by the Assam State Election Commission, the general election to the Panchayat in Assam was held in 2 phases. On Two 2025 and 7/5/2025 respectively. Full stop. The election to Poda Gaon Panchayat constituencies of 40 number Dhumkura Gaon Panchayat, district Morigaon, was held on when? 7/5.
7/5.
7/5.
Yes, my lord.
7/5/2025. Full stop. After counting on 11/5/2025, winning certificates were issued by the respondent number 3 on 20/05/2025. Full stop. The petitioners, the 4 petitioners, and the respondent number 9 to 12 were candidates from constituencies, from different constituencies of 40 number Dhumkura Gaon Panchayat, who were declared elected as Gaon Panchayat ward members on 25/2025. Full stop. After being elected, full stop. The by notification dated 16/6/2025, the respondent number 3 authorized the officers named therein to administer oath of affirmation to the elected Gaon Panchayat members and to conduct the election of the president and vice president of the concerned Gaon Panchayats. Full stop. Insofar as 40 number Dhumkura Gaon Panchayat is concerned, the circle officer, Lahori Ghat Revenue Circle, was the official authorized to do so by the notification dated 16/6/2025 at the office of the Lahori Ghat Revenue Circle on 23/6/2025. Full stop. But the first meeting scheduled on 23/6/2025 was not held. Full stop. By a subsequent notification dated 3/7/2025, the respondent number 3 again notified the first meeting of 40 number Dhumkura Gaon Panchayat and to administer oath of affirmation to the elected Gaon Panchayat members and to conduct the election of the President and Vice President on 10/7/2025, authorizing what is CDC Co-District Commissioner, Lahorighat Co-District, as the officer authorized to do so. Post of para. It is the case of the petitioners as well as the official respondents and the private respondents that on 10/7/2025, comma, only 4 of the elected Gram Panchayat members attended at the venue fixed for the first meeting of the Gram Panchayat. Full stop. It is also an admitted position that on that day, the authorized official administered oath of affirmation to those 4 Gram Panchayat
Ward members.
ward members, and also held election for electing the president and vice president of number 4 Dumkura Gram Panchayat. Full stop. From the notification dated 3/7/2025 itself, it is evident that the meeting held on 10/7/2000, meeting called on 10/7/2025 was the first meeting of the Gram Panchayat as per the subsection 3 of section 6 of the Assam Panchayat Act 1994. Read it.
46.
Read it 46 sub rule 3 of rule 46 of the Assam Panchayat within bracket Constitution bracket close rules 1995 as amended, comma, which read as under subsection 3 of section 6 subsection sub rules 3 of full stop. During the in this connection, full stop, it is a contention of the petitioners that as per sub rule 3 of rule 46, if in the first meeting of a Gram Panchayat, comma, 1/3 or more of the total number of members called to the meeting are not present within an hour of the time fixed for the meeting, the deputy commissioner or the sub-divisional officer, comma, as the case may be, or the officer employed in that behalf, comma, has no other option but to adjourn the meeting pending fixation of another date by the deputy commissioner or the sub-divisional officer, comma, as the case may be, not later than 15 days of such meeting. Full stop. It is the contention of the petitioner that in the meeting called on 10/7/2025, comma, only 4 elected Gram Panchayat ward members were present. Full stop. A number 4, number 40, Damkura Gram Panchayat
has 10 number of elected Gram Panchayat ward members. Therefore, comma, 1/3 would mean 4. Right?
Yes.
Full stop. As in a meeting called on 10/7/2025, 4 were more than 4 were absent, comma, the authorized officer ought to have adjourned the meeting, full stop. Where it is submitted that the petitioners have already preferred an application before the response number 3 under section 11 of the Assam Panchayat Act 1994 as amended, assailing the validity of the election of the president of the response number
And 9, 10.
who?
No, no, no,
Response
9,
number
10.
9 and the response number
9 and 10.
10 as the president and vice president of number 40 Namkura Gram Panchayat. As the said application has not yet been decided, the petitions are before this court. Post of Rule section 11 of the Assam Panchayat Act as amended has laid down that any dispute relating to so and so, shall be decided by the deputy commission. Post of. As the application raising a dispute regarding the validity of the election of the Panchayat and Vice President, President and the Vice President of number 440 Ramkura Gaon Panchayat is pending before the response number 3 as on date, comma, the repetition is disposed of with a direction to the response number 3 to take the said application on board, and after giving an opportunity of being hearing to all the stakeholders, comma, shall dispose of the application upon due consideration and in accordance with law as expeditiously as possible. Full stop. Mr. Roy, Junior Government Advocate Assam, has submitted that a period of, I think 15 days will be, notice has to be given to all the stakeholders. A period of 15 days would be a reasonable time period for the response number 3 to dispose of the application under section 11 of the Assam Panchayat Act 1994 as amended. In view of the same, comma, it is ordered that after putting all the stakeholders on notice, the response number 3 shall decide the application under section 11. As regards the dispute relating to validity of the validity of election of the response number 9 and the response number 10 as the president and vice president of number 445 Ramkura Gram Panchayat within a period of 15 days from the date of submission of a certified copy of this order by the petitioners at his office.
Milord, in the meantime, Milord, impugned resolution dated.
It is ordered accordingly.
In the meantime, Milord, impugned resolution dated 10/7 maybe.
No, Lordship. Decide validity.
Milord, they are
He will decide the validity.
without any Milord authority.
Had you not shown 11, I would have disposed of setting aside.
She has no like locus standi to silence, my lord. At that moment, she was a member.
The documents placed by Mr. Roy
Only one
are
thing, lord.
kept with the case
My lord.
record marking it as document X.
My lord, or maybe also given a liberty to my lord, submit my written objection, lordship. In the
Opportunity of being heard. It is there already.
lordship, oblige.
Obvious.
There is nothing to write written. So the provision, interpret it.
All are transparent.
It 11 to Ekine, Mr. Ahmed, you get that book after some time.
Item 27.
Made, please, Your Lordship. Your Lordship, by
Yes.
by this petition, we have challenged the election to the post of the president of Chaudhary Bazar Gao Panchayat on
Toss of coin.
toss of coin, Lordship, procedural irregularity and lapse on the part of the authorized officer, Your Lordship. On the part of the authorized officer, Your Lordship.
Yes.
File the.
Mr. Dotto. Yeah, file.
Indeed, Your Lordship.
Good. 1, 2 and 4. Yes, they have filed.
Indeed, Your Lordship. They have filed and we are also ready for.
How many toss of coin now? How many petitions? Mr. Dotto,
My lord,
how many petitions still there? Regarding toss of coin?
there are numbers of petitions are there. my lord.
Okay. We'll decide it then day after tomorrow at 3 p.m.
Indeed.
Yes.
Right? Any other petition?
My lord, we have to
Toss
figure
of
it out.
coin?
Figure it out. my lord. We have to figure it out.
Figure it out. We'll decide.
My lord. My lord, lord.
When can you say?
My lord, on next Wednesday, I'll try to give my.
Next Wednesday. No, we are deciding it, adjudicating anything similar.
My lord.
We get it.
But
Listed.
maybe facts are different, my lord. Facts may be different, my lord.
Maybe continue.
Mr.
P.L. Oscar.
Loskar. Petitioner. S.S. Roy. 1 to 4. A.B. Castro.
Respondents have my lord.
Oh, your turn has not come.
Yes.
Learned Council representing R. Dubey. 3. S. Doctor.
5 and 6.
5 and 6. I. Talukdar. Respondent number 7. Post of. So you are to file any affidavit?
I have already filed, my lord.
Filed.
Yes. It is on record.
Long back. Okay.
Yesterday it is breaking on record.
Copy of the affidavit. Okay. The office to incorporate the affidavit in opposition filed by the respondent number 7 in the index. Post of. Release the case. Do you want to file any reply?
No, will not file any report.
Okay. As the learned council for the parties have submitted that exchange of pleading is complete and the matter is required to be decided, adjudicated expeditiously. Place the case on Wednesday. Post of. If the time permits, the case will be taken up at 3 o'clock. 3 p.m.
Much obliged.
Item 28.
Wednesday. Good morning. Always.
May I please?
Archana Saha. Yes.
Lordship, this is regarding non-disposal of application for NOC in composite land sale transfer. Lordship, may kindly peruse page number 40, Lordship. The
Application let notice be issued. No affidavit in opposition. Yes.
Lordship. Application has been made in the month of March, Lordship, and mandate of law is to, pass the order.
Then you file an appeal.
Lordship,
Mandate is already clear, page
We have
40.
also annexed appeal, Lordship.
Ah.
The, interface of the, website shows that, there is some discrepancy in the website, Lordship. So appeal could not be proceeded, Lordship. There we have
Okay, first appeal, where is that appeal?
error in inputs, Lordship. First appeal, we have tried twice, Lordship.
Where is the appeal?
At page number 43, Lordship. '43-'47. We have tried twice, Lordship, to lodge a appeal, Lordship.
Yes, Mr. Who is the authority to this Seva Setu, Mr.
Lordship.
Ms. Hazarika? This is
District
your
Commissioner,
portal.
District Commissioner, Lordship.
Huh? What is this?
Not received.
What is this?
Lordship.
You say that everything has to be online
Lordship.
and you don't maintain the portal.
Lordship, mandate of law you can find at, again, Lordship.
Mandate of law, it is not decided within 30 days.
Yes, Lordship.
Then you have to prefer an appeal.
Yes, Lordship.
And a designated public servant will be imposed with penalty of 25,000.
Lord.
Yes.
Thereafter, second appeal is also there, Lordship, but.
No,
I've
no,
not
if
received the
appeal is,
instruction. I have not
if-
received the instruction, Lordship. We have communicated.
no, this is not done.
Lordship. Let it be next week,
Seva
Lordship.
Setu.
Lordship, let it be on next week, Lordship.
The petitioner lady has been suffering, Lordship. Lordship, may
Wait for at least to
Yes.
see. Everybody has urgency. We are also deciding urgency.
Lordship.
That line you need not have to say. Who maintains? Who is the authority? Revenue and Disaster Management, you are filing this composite land sale transfer notification. You issue notification without the paraphernalia. If the web portal is not working, how can the petition, citizens can get service?
It is.
Appeal is before whom?
Appeal is before the commissioner. Actually, Lordship, this is through website, the Seva Setu portal.
Where is the appellate provision?
Appellate provisions, Lordship may,
In the act.
Lordship may find the memorandum actually at
Okay.
page number 50, Lordship.
Madam? Obsolete thing, page 55.
Commissioner of Divisions, Lordship.
Your citizens are the, have you,
Have to approach Assam State Commission for Right to Public Service. For second appeal, Lordship.
no, first appeal. We are into first appeal, sir.
District
Deputy
Commissioner.
District Commissioner.
Now come to page 55. Don't say without looking at the document. Page 55. This is the service. He is the designated public servant, either deputy commissioner or he is nominated. The appellate authority is commissioner of division, defunct office, obsolete. Where do the citizen go?
To update correction, to amend correction.
So have you rectified or we brought in some modification to the citizen charter? That is a different NHAI. Don't bring in that. NHAI. Is it not? National Highway,
And Lordship,
those are different.
some appeals, those are pending before commissioners or divisions are transferred to the revenue department.
Is it so?
Yes,
Do you have the notification?
there was a notification.
So this service is also to be decided by,
Regarding NOC, Lordship, and
see, if the portal is not working, if the portal, it looks like that is a defunct office. You tried
Lordship,
commissioner.
I have annexed, Lordship.
Yep.
I mean, the procedure is to go.
Mr. Counsel,
regarding
you
That
tried
is-
before commissioner of division or what?
Lordship, I have proceeded to the, portal to which they
Seva
have
Setu.
asked us to proceed, Lordship. To raise the
What is
appeal.
the portal?
Seva Se.
Seva Setu portal. It is written in the application itself, Lordship may find at page number 40, Lordship. May I read, Lordship?
Yes, madam.
Lordship, it's
25.
Because it is showing,
কোন হয় interreligion নাকি bilateral?
Interreligion.
But there is a subsequent notification has been issued, Lordship, on 9/9/2025 for special interreligion land transfer, Lordship. And some guidelines had been given, Lordship.
the guidelines are given, Those are authorities, why they are sitting? To, ourselves to do their job? I don't think so. They have to do their job. So why they are not doing?
Next week, Lordship, I'll.
Lordship,
Huh?
Lordship,
Quick,
next week, Lordship, I
Fixed date, Lordship, I'll.
See, if he has made an application before the designated public servant, right, notified,
They have to.
he did not dispose of. So he has a right to prefer an appeal. That he could not do so because your portal is not working. And you profess that everything is to be submitted online. Take your instruction whether offline he can make an application or not.
Lordship.
Your portal is not there, commissioner of division is not there.
Lordship.
So what to do?
May I add one thing, Lordship? Though the subsequent guidelines, standing counsel on the other side is referring, Lordship, I think that is not applicable because that has come subsequently. Instead of that thing, Lordship, I have preferred I have made a representation to the nodal officer, specially designated for interreligious land sale transfer, Lordship. That is annexed at page number 83, Lordship. Still nothing has been done, Lordship. Lordship may find at page number 83, Lordship.
Who is that guy? What kind of guideline?
Lordship, they have deployed a nodal officer, Lordship, for the purpose of
Is there any
interreligious
guideline?
land sale transfer.
Composite cell transfer order is. Oh, section 21. Yes, the work has to stop somewhere by speaking an order or allowing the application. The buck has to stop somewhere.
Yes, sir.
Yes.
Since March 2025.
Lordship.
What to order for you? I'll put it on Thursday. I'll dispose of unless you place some instruction.
Lordship, next week,
Offline.
Lordship, next Tuesday, Lordship. Next Tuesday, Lordship.
I have invested some time.
Lordship, that's why, Lordship.
I'm not sitting next with you.
Lordship, then Lordship, after 10 days, Lordship, then. Because Lordship, as per our said, some files have been moved, whether his file has been moved or not, that I have to check it.
It's forwarded.
Forwarded some,
Files to the nodal office. Lordship.
that's why,
Regarding the-
But give
Lordship,
place instruction, right?
Lordship.
Heard this, sir?
And M. Azharui.
N.A. Mazharuyan and Council Court of Appeal. The Hazarika Standing Council Revenue 1 and 2. Mr. S. Roy, Newcomer Advocate for the respondents, E26. Both Ms. Hazarika and Mr. Roy have sought for a week's time to obtain further instruction in the matter and to seek clarification. Stop. As paid for. And the prayer is allowed. Release the case on Friday, 10 after 10 days. 15 December.
Right, Lordship.
Withdraw provided for you. Provided for you. Provided. Provided for you.
Item 29.
Lordship, here I pray for 10 more days
No, my
time
lord.
for giving the FSL report, Lordship. I have informed Lordship, the SPS told me 10 more days will.
What is the case?
Now, my lord, the only source of earning of the
No, what is the case?
my lord, regarding selling of
Beef, Lord.
suspected beef, my lord.
Stealing of
My
Selling-
soap, my
soap.
soap, my lord.
Shop.
My lord, on
Soap.
1/7/2025, FIR was lodged against the petitioner, my. Subsequently, he approached his honorable court on the motion stage.
But do you have any power?
Lordship, this was done in terms of this.
Let us see.
You just, this is the status report of the FIR, Lordship. charge sheet,
Status
Lordship.
report is okay.
It is already
Do
there.
we need a source of power? Okay, something has been seized from his office of soap,
My lord.
right? It is under Cattle Preservation Act.
Section 8, Assam Cattle Preservation Act 20.
Offense after section 13(1), my lord.
আসলে যাবে এটা এরকম একটু অয়েল না খুলে যাবে এটা আছে 1 minute. Section,
Offense, case was registered
section,
13(1), my. Page 13(1).
section 31. Any guys.
Whoever contravene.
One. In no, which somebody
13(1), my lord, whoever contravenes any of the provisions contained in this
no,
act
sir,
under
what is the-
section, my lord,
where is the FIR?
FIR, page lordship. Page 15, my lord, operative part, page 17(1)(7), my lord,
17.
1/7.
Acting upon the said information. Seizure.
Where is the power to seal? Lordship, section 196 1, subclause B, BNS regarding issue necessary order for immediate sealing of the 196, subclause 1, subclause B. BNS. BNS. BNSS or BNS also? BNSS. BNSS. 1 minute, 325. Under what offense the case has been registered?
13-1, my lord.
13-1.
13-1 and
325, 3-5 and subsequent.
325.
My lord.
What is 325?
The crime of mischief by killing or
325.
my lord, killing or
Mischief,
maiming
killing
an
or
animal.
maiming animal, I don't know, that is, may not be attracted. 325.
Now, my lord, 196, 1B.
One
my
minute,
lord,
1 minute, 1 minute.
my lord.
25, what is 35?
25 common intent.
3?
35.
35
Fine.
of Bharatiya?
BNS.
BNS.
Okay. Common intent.
Common intent.
Okay. Now, Mr. Roy, which
Yes.
provision you are showing?
196, subclause 1, subclause B.
BNS.
BNS.
196?
1,
1.
subclause B.
Of BNS, my lord.
Regarding issue.
BNS.
BNS, my lord.
BNS.
My lord.
তো এটা ইয়াতে নেমে কি করবো? এই করবো।
196, yes?
1B, my lord, commits any act prejudice to the maintaining of harmony between different.
No, no.
religious-
I am asking about the
Sealing law.
sealing.
That way, on that provision, it has been sealed law.
Where is that? This is BNS.
Lordship.
This is offense.
Lordship.
The procedure and power. You can take the seized material,
Lordship.
conveyance or vehicle used for committing the offense, right?
Lordship.
Then carcasses or the cattle or the material. But sealing of something,
Lordship.
he'll be punished if found guilty.
Lordship.
So where is the source of power, sir?
Lordship, it was sealed.
Let us see your
Two affidavits, my lord.
One by the SP and one by the circle officer, Lordship.
have you have they said about the source of power?
No, my lord.
No, Lordship.
Huh?
No, Lordship.
So
Lordship.
power is assumed.
For peace and SP says, Lordship, to maintain the peace and tranquility, Lordship, it has to be seized, Lordship.
Seized, okay.
Lordship.
Whereas seizing is something immovable property can be seized
Lordship.
unless there is power. The same Sorimal enterprise was sealed as per procedure by the IO, as per requisition submitted by the IO.
Stand of the SP, may kindly.
But he said,
He says that during search, the petitioner could not produce any document.
okay.
And my
Or,
lord,
could not produce document about the seized item.
seized it.
Seize it.
And my lord, petitioner is but license holder.
106. Mr. Roy,
Lordship.
any source?
Your lordship, of course. Just only
You can
to
attach,
lordship,
but
seal is
with the
not
order of a magistrate,
lordship. That
we don't think under 107, you can attach. We don't know about anything regarding immovable property, but anyway, let us, if the property means immovable property,
lordship.
okay, let us assume for a moment. Property includes immovable property. Then it has to be
When is
magistrate. And the application has to be submitted with the approval of superintendent of police or commissioner of police before the court.
thereafter only.
How many meters are there? Okay. Very good. Let's go. Tomorrow,
Lordship.
if any no source of power is not there, we have to order for
Lordship.
opening of the shop.
Lordship.
Mr. J. Oscar petition. SS Roy, branch, for all the state responding. Poster. Release the case again tomorrow. For party hearing.
Item 30.
Hey, please. Lord. Matter relating to election of president. Cow concern.
Yes, respondents. What happened?
This case, my lord, the
I think instruction not declared.
petitioner and the respondent number 7
It
were
will-
elected as a member. And petitioner number 1 and 7 contested for the post of president. Both got 5 equal votes of 5, my lord. But after counting the vote, my 1 vote has been cancelled on the ground that privacy has been left. So we approach this honorable court. An honorable court directed to appear before the deputy commission. We appear, file an appeal that was disposed of. And
Okay, earlier you approached.
lordship. And
Where is
the
the order?
earlier order, my lord,
Ah.
is number 36.
It is a dispute. 44, 46, sub rule 7.
Lordship. Deputy commissioner is directed to conduct the hearing. before the
46, 7. Oh, Panchayat Pancha, however.
46-7, my lord. 215 is the.
Yes, Mr. Doctor.
My lord.
Does
My
not
lord.
comply.
His only grievance is that, my lord, the case is, the petitioner is that, my lord, that secrecy was not maintained. And rule is saying, my lord, lordship may have the book, my lord.
Sure. Yes.
46 sub rule 6. Page 214 of the book, my lord.
Sub rule 6.
Yes. May I read, my lord? If more than one candidates have been proposed and seconded and have agreed to stand for election, the officer authorized under sub rule 1 shall conduct the election in the following manner. 1. The officer as under sub rule 1 shall cause to prepare as many ballot papers as there are members present in the form 4 in the language of the region, and whereupon the names of the candidates shall be written line-wise in the order in which the proposals were made. The officer authorized under sub-rule 1 shall allow the members present to inspect so and so to be used for the purposes and thereafter secure and seal such ballot box and place it in front of him. He shall provide a compartment screened from observation by any other person in which the member can mark the ballot papers. So this is the provision, my lord. That those election should be held inside a screen compartment, my lord. And lordship may kindly see the next page, my lord, from 7, my lord. Sub rule 7, I am reading in the 215, my lord. Immediately after the voting is over, the officer authorized under sub rule 1 shall open the box, take out the ballot papers therefrom, count them and record the number thereof in a statement. A ballot paper shall be invalid if the A, my lord, it bears the signature of the voter or contain any word or visible representation by which he can be identified. So secrecy has to be maintained, my lord, and admittedly in the present case, my lord, in hand, it was openly.
Visible representation by which he can be identified.
Yes, my
What
lord.
is that? What is that?
Lordship, it's directly not saying
Ah.
that.
What did why, for what reason?
Because, my lord, secrecy
Leaked
was not
photo.
maintained. Yes, captured photo, my lord, secrecy was not maintained.
After
Photo was
booking
not captured.
and after instruction,
not
order, the
recovered.
photo was deleted. So, he flashed the light,
Yes.
page 51, while casting vote inside the compartment.
Yes.
Huh?
Lordship.
Flash the light. You flash the light
Place the light for my lord.
to ensure that he has casted his vote in the right place, as there was lack of sufficient light inside the voting compartment.
There's the light, but that photograph, whether his photograph has been captured, the photograph that was not recovered from his mobile. And my lord, vote after vote,
No,
count is over.
it's your statement.
Counting
Let
is
us
over.
forget others. Are you not saying that you have flashed the light of your mobile while casting vote inside the compartment to ensure that he has casted his vote in the right place, as there was lack of sufficient light in the voting compartment? That is your case.
Lordship.
This is your case.
Lordship.
So, whether you have violated the
No, in my lord,
My lord, photograph flash
47,
and
my lord.
normal light is different, my lord.
46-7, my lord.
Flashing for a camera, my lord, to take picture and open a torch in the phone, it's totally different, my lord. From outside, it can be, my lord, visible, my lord.
47-6, my lord. There's a-
in this short time, I have read something which you have not read. None of you have read. I
Well,
have
it's-
read already, which you have not read. Go through the provisions again. Right. A citizen cannot take the plea that you do not know the law.
Yes.
And it is more forcefully applicable for an elected candidate who proclaim him and who wants to be the representative of the people.
The petitioner number 2, my lord.
Anybody wants to file? Yes, Mr. Motin. You are private,
Private respondent.
selected. Would you like to file any affidavit?
But I have already completed reply me.
Where?
Of the past.
You filed a reply?
Tomorrow I can file.
File it. Mr.
My lord, my colleague will file my for
Lordship.
district commissioner representative.
Both you file.
Lordship.
Okay, H.A. Amit, petitioner, as doctor, planning council. I'm going to repeat for you. SS Roy, junior government advocate, 236. AB Kayasto. On behalf of R. Dubey, look at you. to 5, A.M. Ahmed, 7. Yes, Mr. Roy, anything? You can get the records.
Lordship.
Record?
I think that will be better.
Lordship.
By filing a affidavit, misinterpreting the law.
Otherwise,
records-
everything is in the repetition itself.
Everything is there. You have admitted, you flash the light inside the compartment. Right? On that basis, you have to decide.
Yes.
But in 46(7), my lord, there is no such clause, my lord.
But
Flashing light, my lord, that will be invalid the ballot paper, my lord, there is.
well, decide.
And deputy commissioner, my lord, by applying people's application.
Lordship, get the records. Mr. Roy, Land Counsel for the petition has sought posting of the case after 1 week to obtain the relevant records of the proceedings. Mr. Motin has paid for and is granted 1 week time to file an affidavit in position on behalf of the respondent. If the prayers are allowed, list the case. Decided. Next week for election or New Year? New Year?
Well, short date may be given.
New Year.
Before vacation, well, kindly, before vacation.
Put it 15, I don't know. 15, 16, 15, 16, 16.
I love lesson.
Item 32.
Has been acquired by the government of.
The affected PJ appears to be the owner of the.
Doing the wrong tag number.
What happened? Late. File your affidavit.
Lordship.
Mr.
AN.
A.R.
AN.
A.N. Rahman.
Ahmed.
Ahmed, petitioner. Henrik, Standing Council. Revenue disaster 1. SS Roy. 2 and 5. Yes. Is the owner of a plot of land. Mr. Roy, you filed affidavit?
Lordship.
Also, you are for 2 and 5?
Lordship.
Or all, for all?
For all, Lordship.
For all, Standing Council, Revenue or Vakil Ki?
We already been communicated by instruction to be received.
How much time? Mr. Henrik has sought for and is granted 3 weeks time to file counter affidavit on behalf of the official respondents. First up, the price allowed is the case after 3 weeks. The interim order passed earlier shall continue till the next list.
Item 33.
33 Lordships. We sent for vetting, while it is received, Lordship, it's some time being granted to file affidavit.
Okay, how much time?
It's only 10 days. For the huge, all of the documents, we have.
Oh, you are having status quo order.
Yes.
A.M. Ahmed Learned Council for the petitioners. One petitioner or many? How many?
Lordship 68.
Petitioners. Any standing council, revenue?
Lordship, I appear on behalf.
Okay. J. Henrik Standing Council Revenue and Union Government Advocate for the state respondents. Respond number 1 to 5. 1 to, for all the respondents. Mr. Henrik has sought for and is granted, has submitted that the affidavit in opposition on behalf of the state respondents has been sent for vetting. And has sought for listing of the case after 3 weeks in order to enable him to file the counter affidavit within 3 weeks' time. The price allowed is the case after 3 weeks. The earlier interim order of maintaining status quo stands extended till the next date of list.
supplementary list, item 52.
That matter, my lord, regarding that big clean, my lord. Last over, lordship asked the owner forest to file affidavit. They managed.
They have filed affidavit, it is full by Mr. Ibot has voted, today they filed affidavit.
Filed.
It's not on record.
Okay. Yes, when do you want with the city affidavit on record? Vikiri Bahar Burua. RR Gogo has filed.
Ibot Thakur has the order
Okay.
for it.
Mr. J. Hendrick. New government advocate, 3 and 4 file body, I got that. Agriculture, anybody? No.
They filed, my lord. They have filed.
BP Bora, Learned Council for the respondent, 12 are present.
I'll also,
It is,
I'll also file a reply.
it is submitted that by Mr. Borua and Mr. Bora that an affidavit, an additional affidavit has been filed. I have got copies.
No, not yet,
Okay. Not yet.
not yet.
And they have been informed by the Land Standing Council Forest Department that an affidavit in deference to the order dated 13/11/2025 would be filed during the course of the day. So, okay. And that view of the matter, let the case be listed after a week with the said affidavit on record, listed on 8/1.
Lordship, my lord.
Let the affidavit come first.
Yes. Can it be on it?
8/12, I'm sorry, 8/12. Let the affidavit come, thereafter we'll see. Deeply.
Item 53.
Can it be on 9/12, my lord?
No, first let us have the affidavit, then we'll fix. You have been told that we'll file. Sometimes it turns out that no affidavit is filed. If required, we'll put it on then thereafter. First, let us have the clerical thing. Were agree by the election or as a one member subsequently as the president. More than 2 children.
My lord, lordship can dispose it of, my lord, under section 11, DC can decide, my lord. Already representation is pending, my lord.
An outer limit may be.
Heard Mr. R.A. Chaudhary. Learned counsel for the petitioners. As Doctor. Standing Council, Panchayat and Rural
I am for, my
Development
lord.
Department for the respondent number
1, 3, 5, 6, and 7.
Casto is available now.
Lordship, I am for 8, Lordship.
8.
Private
Mr. J. Henry, learned Union Government Advocate Sam for the respondent number 4. And Mr.
M. Alam, Lordship.
M. Alom, learned counsel for the respondent number 4.
8.
8. Full stop. The petitioners. They were contesting parties or voters?
Petition number 1 is, all of them voters are yellow.
Voters.
Yes, sir.
Okay. The petitioners. The 3 petitioners. I have claimed that their names are enrolled as voters in for the Panchayat general election Assam Panchayat General Election 2025 as voters from ward number 4 of 61 number Zamira Gaon Panchayat. Also. The respondent number 8 was a candidate who submitted nomination papers for his election as a ward member from ward number 4 of 61 number Zamira Gaon Panchayat in the said Assam Panchayat General Election. Full stop. After his nomination paper was accepted, he contested in the respondent number 8 contested in the election and was declared elected as a ward member. Full stop. Subsequently, in the first meeting of the Gaon Panchayat, held on 8/7/2025, he or she? He or she?
Lordship.
He.
He. He was also elected as the president of number 4, 61 number Zamira Gaon Panchayat. 8/7/2025 করলো না? Para. The petitioners have contended that the respondent number 8 suffers disqualification from being elected either as a member or as a president or to remain as member or president of a Gaon Panchayat as he suffers disqualification as he lacks the qualification laid down in section 111(2) within bracket small a, 2 bracket small a, and section 111 within bracket 2 within bracket F of the Assam Panchayat Act 1994 as amended. 2A. Moral turpitude, convicted. Then why said paragraph 4? Eleven two A.
11(2)(a) is for more than
Conviction.
two living children from a
Okay,
single.
2 living children.
Yes.
2A. Read with section A, paragraph 4. ऊपर लिख सकेंगे हाँ hesitating such claim, the petitioners have stated that they had already submitted complaints before the respondent number 4 on 27/6/2025 and 11/8/2025 seeking declaration as regards disqualification of the respondent number 8 and for his consequential removal from the post of ward member and the president of number Gaon Panchayat. Also, as the complaints filed by the petitioners are not given consideration by the respondent number 4 till date, the petitioners, aggrieved thereby, have approached this court by the instant writ petition, seeking inter alia direction to the respondent number 4 to dispose of the complaints, dated 27/6/2025 and 11 dated 11/8/2025. Full stop. Para. As per where is the provision? 62.
Rule 61F, Lordship.
62 1F.
Rule 62, Your Lordship. 62 2F. Page number 226, new one. And
The
62 4C.
The provisions of Rule 62 of the Assam Panchayat Constitution Rules 1995 as amended have laid down the conditions and procedure of disqualification under subsection 2 of section 11 of the Assam Panchayat Act as amended. Full stop. Rule 62. Two, Rule 62, 1,
Rule 62 2F, Lordship.
2F.
Yes, Lordship. This is 1F, man.
1F.
Sorry, Lordship, 1F. 1F. Sorry, Lordship. Rule 62 4C.
1F has provided the conditions and procedure of disqualification under section 111 within bracket 2 of the Assam Panchayat Act 1994 as amended. If the complaints are with regard to more than 2 living children from a single or multiple partners. Full stop. As per Mr. Dottal and Planning Council, Panchayat and Rural Development Department, Henrik, have submitted that, as well as Mr. Spencer, Land Council, for the response number 8, have submitted that since the petitioners have already filed complaints on so and so and so and so. And the Deputy Commissioner and the respondent number 4 has the authority and jurisdiction to examine the matter and for removal of an elected president or vice president or member of a Gaon Panchayat on establishment of fact, this petition can be disposed of with a direction to the respondent number 4 to decide the complaints after affording a reasonable opportunity of being heard to all the stakeholders, including the petitioners and the respondent number 8. If the complaints lodged have not yet been disposed
In outer limited.
of. Para having regard to the provisions contained in section 111(2).
And also 4A also, my lord. 4A. 229 page number.
2A.
229 page number, your lord.
2A.
4A.
Huh?
The second complaint was under 4A.
Okay. Section 4A means?
The rule, my
Rule,
lord.
page
Page
number
229.
229, lord.
I'm holding the whole book.
Rule.
Rule.
In that book, it is not there, my lord.
4.
4A, my lord.
Read it.
Procedure is 4C.
Read it, rule 62. 1F. And rule 62, 4A.
4C, C is the procedure.
C is the procedure.
Yes, sir.
4C. এমন নতুন এখন আনিবহে 4C of the Assam Panchayat Constitution Rules 1995. The district commissioner has been vested with the power, authority and jurisdiction to decide on this petition is disposed of with a direction to take the complaints submitted by the petitioners on so and so on board. And thereafter, and after affording the opportunity of being heard to the stakeholders, shall consider the same and consider and decide the same by way of a speaking order. Poster. It is accordingly ordered. Poster. It is further observed that the complaints are to be the speaking order is to be passed as expeditiously as possible and within an outer limit of 1 month from the date of submission of a certified copy of this order by the petitioner before the office of the respondent number.
Okay.
Deeply applies.
Highly applies.
Timing method, item 18.
Order dispose of the writ petition. Some other day. Mr. Borua,
My lord, in this matter, today we have filed our affidavit in
not
opposition.
possible today.
Today, my lord, during the course of the day, a copy has been served to the.
Some other day.
My lord.
Release the case. On side you got a date, huh? We'll give it. Yes, anything? Yes, anything to be mentioned? Yes, Mr. Islam.
41.
Too urgent.
After vacation, fix a date.
Which one?
Pleadings complete, 42.
42.
41 also connected there, 41, 40.
Okay. What is the matter about?
In this case, illegal.
42.
42 years.
41, 42 together.
Whether the contempt is there.
Okay, on Mr. S. Islam, learned counsel for the petitioner.
Pleadings complete years.
And Mr. Revenue, Miss, yes.
I am for 47. He is.
J. Hendrik Revenue at present. Release the cases after 2 weeks. And 2 weeks by the office. Let it be after next day.
Lordship, item number 54, Lordship.
54.
Lordship, item number 54, Lordship, my lord may kindly issue notice with the contempt matter. This honorable court has directed me to take instruction. I have received instruction, but notice may go, my lord. 2025. I have received updated instruction, my lord. It's pending.
What is the matter about?
It's there is a
Court passed an order directing.
Compensation.
yes, 1 lakhs of compensation, Lordship. Is it pending before the finance? Now finance has forwarded it to judicial department. So Lordship may notice may go, my lord.
Finance is a party or not party?
No, my lord, for it's not a party. That's why it's
Directed by this honorable court, Lordship.
Oh, heard, Mr.
I'm R. Islam, Lordship.
R. Islam. Learned counsel for the petitioner. Closed up. Ms. Emily Bora, Learned Counsel.
Lordship, notice may go, no, call number has been filed till date. Honorable,
Stated that he has not yet received any ukalatnama
Lordship,
from the alleged
respond.
respondents. Closed up. This contempt petition is filed alleging non-compliance of the direction made in an order dated 22/4/2025,
25.
passed in a writ petition WBC number 762/2025. It is submitted that the copy of the order was duly brought to the notice of the respondents. Post of issue notice returnable 4 weeks, steps based at it post
Deeply obliged.
within 2 working days.
Any?
Any interim order, madam?
No, Lordship.
Contempt matter, Lordship.
Contempt.
Some
No,
direct.
I am asking others.
Deeply obliged.
Item 35. I may withdraw this petition.
Okay. Miss
Miss A. Hussain, I am appearing on behalf of J. Ahmed.
A. Ahmed, Miss A. Hussain, Learned Counsel, appearing for Mr. J. Ahmed, Learned Counsel for the petitioner, has submitted that the subject matter of the petition has become infructuous by flux of time. Post of. You were there?
No.
In view of the above, anybody? 35, Mr. J. Henrik Learned Junior Government Advocate for the state respondents is present. In view of the above submission made by the Learned Counsel. Huh? Miss So-and-so? Spence close as infractious.
Lordship, in item 47, my lord had already disposed of the review petition. The IA that they have filed before the disposal of the review petition,
Yeah.
but that was not tagged at that time.
Oh, that's
Yes, Lordship, but it is wrongly listed, I think. Review already has.
Arsidas.
Lordship. Yes, my lord.
That English law.
My lord. This IA, they bring on record the instruction that I have produced before my lord, that election notice.
What was the review petition?
Lordship, review already been disposed of. This IA.
Review, this IA was disposed of.
2 IA was filed, one for delay condemnation and another one they have filed before disposal of the review petition, but that is not listed on that day. They bring on
Yes.
record the instruction that I have already produced before my lord, that election notice.
Bora, Learned. As a standing counsel.
Lordship,
Standing Counsel Corporation Department is present. Close up. And the instant interlocutory application is filed seeking stay of a notice issued by the respondent authorities on 17/10/2025 for conducting election of Hatual Rupohi Homobai Committee during pendency of an interlocutory application, IAC number 2197/2025, which was referred seeking condonation of delay in filing a review petition, review petition number 81/2025 within bracket filing number. Close stop. By an order
12/11.
by an order dated 12/11/2025. The interlocutory application, which one? What is it? Oh, yeah, that's it. The interlocutory application, IAC number. Oh, that good.
360.
Was C number 2197/2025 was dismissed. And consequently, the review petition number so-and-so filing number was also dismissed on
12/11.
12/11. First of in view of dismissal of the above dismissal of so-and-so, I number so-and-so and review petition number so-and-so. This interlocutory application has no cause of action for further adjudication. And accordingly, the same is dismissed.
My lord, you oblige, Lordship.
Item 45, Lordship service has been not been complete for a long time. They have issued dusty on previous occasion.
Some other day, sir, I have a meeting at 4:30. Pass the order some other day.
Of like this.
Take the date from there.